Good morning, aspirants. Welcome to Dr. Rajkumar IAS KS Academy. As part of our Decode UPSC Prelims 2025 program, we bring you previous year questions analysis for Indian polity by Advocate Muhammad Idris sir. Advocate Muhammad Idris sir is a seasoned faculty member at Dr. Rajkumar IAS KS Academy with over 17 years experience in legal practice and 10 plus years of teaching experience in Indian polity and sociology for UPSC aspirants. Holding multiple degrees including LLM, UGC NET and a PhD, he is known for his deep knowledge, engaging lectures and student-friendly approach. A qualified civil services mains candidate multiple times, he has also served in the Tamil Nadu government. He actively contributes to the curriculum development, participates in public debates, and supports social causes through NGOs. Renowned for his oratory skills, he is admired as a walking encyclopedia by the students. Please welcome Advocate Muhammad Idris, sir.
Company was mandated to mandate first time East India Company was mandated to give their details, revenue expenditure details to the British Parliament. British Parliament started regulating it, and again the company professionals, the company workers were not allowed to do private trade. Okay, bribery again was a bigger issue. Here, if you see here, 1773 Act, what would be there? Huh? So B will be what? The company's director was to the British government correspondence of training. That is there. B4 directed. Okay. Then if you see here, corrections to it brought by the Pitt's India Act, named after the Prime Minister William Pitt. Most important thing, Board of Control, Board of Directors, 2 divisions. Remember it or not? So Board of Control, Board of Directors, 2 divisions was done. And this is Pitt's most important item. And the British possession, the East India company's possession, company's territory came to be called British possessions in India. 1884 Act, an important one. And again here, if you see here, what would be there? With regard to D, set Board of Control. Understood or not? So Board of Control taken from Court of Directors. So that is there. Then the 1793 Act, one very important item. See, every item we cannot see. We are touching and going. Very important item is that the revenue of the British personals be charged on Indian revenue. Sorry, the salary of the British personals to be charged on Indian revenue. So the Court of Board of Control, who will take care of the administrative affairs of India for them, and the British professional administrative workers, salary will be paid from Indian revenue. Separately, what India gives as tax, it will be paid. This was one important item. Then 1813 Act, very, very important. For the first time, 1813 Act, British East India Company's monopoly over Indian trade was restricted, not eliminated. Except for tea and opium. Except for tea and opium, this was restricted. Okay. Tea with regard to China, this tea with regard to India, opium with regard to China, interchangeable. Okay. So this was done in 1813. First time Christian missionaries were allowed to come and preach in India. First time British even stated that British Parliament stated 1 lakh rupees should be set apart for Indian people's education. So this and all was primary item relating to 1813. Here 1813 would be what in this? Out of what is given? 2. Companies trade monopoly in India ended. Actually speaking, except T end. But given the option, that is the option. If that open-ended statement comes, it is 1833. 1833 only complete monopoly stopped. Even for tea and this one, opium. So that is that went away. So 1773. So here, coming to 1833 again, one of the most important acts with regard to 1833, Governor of Governor General of Bengal becoming Governor General of India. Governor General of Bengal becoming Governor General of India. So that is again one important aspect that happened with regard to this. Understood or not? So here, apart from it, before that, I have said before also, many a times asked, so again repeating, 1820s, Colonel Sleeman, suppression of thugs. Thugs were suppressed by a person called Colonel Sleeman. So suppression of thugs happened under his this in between this period. Then 1829, first time social legislation by British, anti-sati law. 1829, anti-sati law was brought. 1833, so these things and whatever I have said to you. Then coming to 1853, 1858, when other chance comes, 1853 we will talk. 1858, most important thing, complete administration went into the hands of, it is also called Queen Victoria's Proclamation. And according to this Queen Victoria's Proclamation, it is also called Act of Good Government in India. Act of Good Government in India. Secretary of State as a position came up from 1858 Act. That Viceroy and the Governor General of India now it came to be called Viceroy and Governor General of India. 1858 Act. Viceroy and Governor General of India assisted by Secretary of State with a 15-member advisory body, and the Secretary of State is a cabinet minister of British government. All this, got it or not? So these are all there. Keep it in this. What would be the thing? 1858. The power to govern was transferred to East India, transferred from East India Company to this. Okay. Then which one of the following act? Portfolio system. Portfolio system was introduced by whom? Different ministries. Portfolio system introduced. We don't have time. Canning. Not like class. Be a little more active. Canning. Okay. Canning introduced. It was in 58, 59 introduced. But 61 Act, 1861 Act emphasized this, legalized it. Portfolio system. Understood? So 1861 Act, portfolio or the departmental system came into existence. Who was there? First when it was introduced? Lord Canning. Okay. So that is there. It's a straight one. Okay. Portfolio system, Lord Canning, where each one got assigned. Separate this one. Then which one of the following provisions was not made in the Charter Act of 1833? 1833, not made. So the trading activities of East India Company abolished or not? They completely abolished, I said. Then designation of supreme authority was changed as Governor General of India in. Then Governor General's Council came to be called Indian Council. First time, 1833. Okay. All law-making powers to be conferred to Governor General in Council, and Indian was appointed as law member in Governor General's Council. Which of it is blatantly wrong? Okay, D. Looking at it wrong. Indian member not appointed. That time, Law Commission. Yes. But Law Commission got set up 1835. Law Commission later to 1833 only got set up. Who was the first Law Commission chairman? Macaulay. Okay, Lord Macaulay. M.C. Sitalwat was Independent India's first Law Commission chairperson. Who is the recent 2020 set up Law Commission chairperson? In current affair material, I have given that. The recent Law Commission. Okay, fine. We will come to it. Chauhan. Okay, fine. Here. So D. Charter Act of 1833. Here. These are all there. I have put it also. European settlement encouraged. Restrictions on European immigration, land ownership in India were removed, having way for full European colonization. Few extra points has been given. I have given what not in books also. So the notes what I am sending this time writing, even not writing this time also, but this time writing means read it, read the explanation, because few extra points I have given wherever possible. 1833 you see these points many books won't have. So restrictions on European immigration was there. Then centralization of power, extended authority of Governor General, gained authority to supervise all civil military affairs. Then to control over territory, all this reduced powers for Madras and Bombay, abolition of slavery, very important thing. An attempt, administration was instructed to improve the condition of slaves, but it was abolished in 1843. Slavery, British abolished in 1843. But 1833, they were asked to improve the condition of slaves. Understood? Keep that in mind. Read what I am sending, read. Okay, with reference to colonial rule in India, Ilbert Bill. What is about Ilbert Bill? Lord Ripon Cairn, little bit of liberalization. He wanted Indians also, he wanted to allow eligible Indians also to take part in what? As judges, to sit as judges. How can Indians sit and hear Englishman as judges? Was the bigger issue, and ultimately this is called Ilbert Bill controversy. They nullified it. What is the answer to it? Okay. Yeah. Then who among the following repealed Vernacular Press Act? Vernacular. Here it is Ripon. Here it is Ripon. Okay. Given it is Ripon actually. See, actually speaking, Vernacular Lytton used it. Lytton was a hardliner, used it, Ripon removed it. Okay. What is Vernacular Press Act I have given? Seditious writing, empowered district magistrate. They were authorized to require printers and publishers to enter bonds, prohibiting content that could incite disaffection and disloyalty. So 1878, that act, government censorship, what kind of security deposit? See, they were allowed to pay huge security deposit. People were discouraged to go for printing and all. Okay, these are all there. So this is Montagu Chipford, based on what? Montagu what? 19? Minto Marley? 1909. 1919 Act, one of the numerous times asked act. Diarchy in provinces. Speaks about what? Diarchy in provinces. When I say diarchy in provinces, what do we mean? Two, transferred subject, reserved subjects. For the first time, provinces were given the right to have certain list to make laws on their own. Was in 1919. Two list, provincial list, federal list. Federal there means central list. Okay, in that provincial list, transferred, reserved. Reserved for whom? Governor General and his council. Transferred to the elected members. This is diarchy in province. This diarchy in province abolished when? 1935 Act. This was abolished in 1935 Act. Keep this in mind. And in 1919, lot many are there. Anyway, we will be seeing there. So that is that. So here, so special features, if you see, as I have put here, it's a transfer. See, this question itself they have asked. Whether this came under transferred list or reserved list. Likewise. Some reserved subject, law and order, finance and all was reserved. Transferred to education, health, even local government was transferred subject only. Local government was transferred subject only. So these all were there stated. So consider the following statements. Government of India Act 1935 provided for what? 1935 Act is also the prelude to our constitution. Close to 60% of our constitution we took from them only. So in 1935 Act, for the very first time, a name called All India Federation as a word came into existence. But it never became a reality. Why? All India Federation consisting of British Indian provinces and princely states. British Indian provinces and princely states. This was what was stated. but more than half of the provinces, the princely states, sorry, more, if the princely states agree, only this will happen. They never agreed, it didn't happen. But the term All India Federation came into existence. India means these are all from 1935 Act. Very important one. Okay. Similarly, what else? Establishments of federal court. Supreme Court till 1950 was called as Federal Court. Supreme Court was called as Federal Court. 1950 only we made it Supreme Court. Okay. That is there. Then All India Federation at the center. It is there. Got it or not? So here replaced system of diarchy. Why? State diarchy abolished, I said or not? Diarchy in province was abolished in 35. So provinces got independence. Independence means, sorry, autonomy. But same thing, union, they started having what? Diarchy. Union level, they started having diarchy. Understood? Keep this in mind. That is again important. And All India Federation again. So this came up at federal level, executive level. The provincial autonomy. With regard to 1935 Act, on mains question also I have put here. 2016 asked mains question. Answer completely I have given. Complete answer I have given. Read that once, which will be useful even for prelims. Any question they ask, little more from it. See, many questions from 35 has come. The residuary power under 1935 Act rested with Governor, Viceroy and Governor General. Another one item. Okay. So RBI again came out of this. Burma and Eden got away from India or delineated from Indian administration, not India. Indian administration. So here, 1853 abolished East India Company monopoly of Indian trade. Yes. Okay. Under the Government of India Act 1858, British Parliament abolished the rule of East India Company and took the responsibility to do rule directly here. Got it or not? 1813 abolished. Actually, 1833 abolished fully. Okay, fine. Got it or not? Instrument of it. This one is what? DPSP. DPSP we took from. But why I have put it here? Instrument of instruction in 1935 Act they stated. They stated in 1935 Act they have stated about instrument of instruction. Then distribution of powers between center and state of Indian Constitution is based on today. Today we have 3 lists or not? We have residuary list or not? From which act it came? 1935 Act. Objects of Queen Victoria's proclamation. 1858 is Queen Victoria proclamation, I said. What are the objects of it? Hereafter 1858, which is the only the British government crown said, we are not going to annex any other part of India. They have said it after 1858, which was the only kingdom they annexed after it. When? Avadandal. No. Why Avad? Avadandal aligned with the British. Later on. Okay. Different kind of alignments were there. Fine. Manipur, 1894. Said it. Once asked a question also. Fine. So, but they told they are not going to annex anymore. To place Indian administration under British crown. To regulate East India Company's trade with India. What is the answer? Okay. So here 1 and 2 only. Why 2 only? To disclaim the annexation of. They said they will not annex. Even after that, only one they annexed. That was Manipur. Okay. This is correct only. 1 and 2. Okay. Clearly defined what? A 2015 question. Nowadays, in this part, the questions are asked are little deeper, not what is there in straight away books. Okay. So here is the jurisdiction of central and provincial governments. So please keep it in mind. In the Federation established Government of India, residuary power, whom? Now only told. Consider the following: 1813 Act entered a trade monopoly except for trade with tea in China. Tea is India and China, opium. It asserted the sovereignty of British crown over the Indian territories held by the company. The revenues of India are were now collected by the British Parliament. Now controlled, by the British Parliament. Wonderful question. This is 2019. Right after 2013-14, the questions from this topic are all little deeper. Normally in books, whatever available, not there. Okay, here, if you see this 1 and 2 only. So it ended trade monopoly, it asserted sovereignty of British crown over Indian territories. Got it or not? So that is there. So the Montagu-Chelmsford reform of 1919, granting vote for women, age of 21. Is it so? It only said, it did not even bar women. It only said that there are certain criteria for women to vote, that's all. It stated about criteria only. Okay. It did not bar anyone. So that is wrong. Then Government of India Act 1935 gave women reserved seats in the legislature. Is it so? Along with women, who were the other part? The women were reserved. Who was the other one? First class separate. Okay, depressed class. Okay, that's what depressed class he says. Yes, see. Anglo-Indian 1919, separate electorate given, reservation. Laborers. Okay, so laborers, got it or not? So they gave for laborers also. So women and laborers, in my notes, that what I used to send fully, in that it is there. So with reference to Government of India Act 1935, consider the following statements again. Last year question. Twist for many. See, last year question. Reserved subject, transferred subject. See, it provided establishment of federation on the Union British. Easy. First, okay. Second one. Defense and foreign affairs were kept under the control of federal legislature. Federal legislature means transferred. Hierarchy in center, transferred. Reserved means for Governor General. He reserved what? Defense, foreign affairs, tribal matter, eclectical matter. I have told this before. Yes, here also I have written somewhere. See, reserved subject, which included foreign affairs, defense, tribal areas, and eclectical matter. Eclectical means what? Which matter? Matters related to religion. Matters related to religion. Eclectical matter. 4 items reserved for Governor General. Rest all transferred. Got it? Fine. So this question, 2016, whole answer I have given. Okay. So you go through it once, even for prelims, it would be useful. Okay. Now, preamble this question. See, what is that answer? See how they have asked 97 question. How and all they have asked? They asked X stands for what? X stands for my ex lovers are. Who left me? X stands for what? 19? 26th day of November 1949. Okay. Okay, Deepali, correct. Okay. Fine. B only. So economic justice is one of the objectives of Indian Constitution. Has been provided in preamble and DPSP. Likewise, if you answer, I'm also happy. Otherwise, I alone keep on shouting. Which one of the following objectives is not embodied in the preamble to the Constitution of India? Simple. So liberty of thought is there. This economic liberty, is it there or what? New message. Okay, fine. Deepali, which one C you have said? I don't know. This is economic liberty. Okay. So, I think maybe the before one. So, which one of the following objectives is not embodied? Not embodied is economic liberty. Got it or not? So, that is there. The mind of the makers of the constitution is reflected in which one of the following? Basically asked means preamble. Okay. Fine. I think I can keep this also open. Let it be here. Yeah, I did wrong. Sorry. My technical fault. Yeah. No, this will not help me. The preamble of the Constitution of India. So here 2020 question. This I always used to say. But in books it is there, straight only. But little thinking. A part of the Constitution but has no legal effect. Not a part of the Constitution and has no legal effect either. A part of the Constitution has the same legal effect. A part of the Constitution but has no legal effect independently of other parts. Let us see what they are saying there. D. Daddy is correct. D. I said this before. D I have said before also, no. D, that is a wonderful question. On its own, it has no value. It is part only. If on its own it is value means the state can make a law simply by stating, see, sovereign, so we will do something else. Got it or not? So on its own it doesn't have. Independently. It can be an interpretation. It can be interpretation tool, explanation tool for other this one. Okay. So that is there. Then other than fundamental rights, which of the following parts of the Constitution of India reflect the principles? UDHR. UDHR notes, along with its notes, I will send to you. In that you will find fundamental right, DPSP, all articles one side. Then the UDHR articles on the other side. Have just a look. For prelims also have a look. Here it is 1, 2, 3. Because when UDHR was made, same time we were making our constitution. India was signatory to it. So its reflection in whole of the constitution is there. Okay, UDHR reflected 30 articles are there. So its reflection is there in whole of the articles. Yes, Adarsh Akshit, correct. Okay. Now, what was the exact constitutional status of India on 26 Jan 1950? Sovereign democratic republic. Okay. So sovereign democratic B, yes. Sovereign democratic republic. Now, who among the following was the chairman of Union I used to say, ask the question 2005. Even this year I am expecting. Every year I used to expect one question from there. So it's long time. So committees. Who headed what committee? 22 committees are there. 12 substantive, 10 procedural. And in that I have also said which are all committees headed by Sardar Patel and Jawaharlal Nehru. At least have a note of it, I have said. Okay, this one 2005 who? Jawaharlal Nehru, answer correct. Okay, Jawaharlal Union Power Committee as well as Union Constitution Committee. See there, both are different. Provincial Constitution Committee, Patel. Fundamental Rights and Minority, who? Who was taking care? Who was the chairman of Fundamental Rights and Minority Commission? Sorry, committee. Patel, Sardar Patel. Okay, so this keep it in mind. Drafting committee, I told all the names. Keep it in mind. Drafting committee, Dr. Ambedkar, Krishnaswamy Iyengar, Alladi Krishnaswamy Iyer, K.M. Munshi, Syed Sadullah, Madhav Rao. So all these are there. Earlier Kaitan was there, then he went away, and So this, please keep it in mind. Deepali Patel, yeah, you are saying for, yes, vulnerable rights minority, okay. With reference to Indian history, the members of Constituent Assembly, here is a problem. From the provinces where, with reference to the Indian history, the members of Constituent Assembly from the provinces where, what? Constituent Assembly, elected by the provincial legislative assemblies. Okay, is it correct? They were elected indirectly. That means they were elected from where? Provincial election alone happened. We did not conduct for whole India election, only provinces. Meanwhile, rioting, partition, all came up. So what? Immediately, okay, from the elected 389 members, 296 plus 93. In the 296, 4 are chief commissioners, provinces. Total 389. After partition, how much it was? 299. 229 plus 70. 70 princely states. Even here I will say, have a look at which princely states had how many number in Constituent Assembly. At least the higher and all. Mysore and all had one of the highest numbers. So please have a look at them. Even there is another thing. Those time, the kingdoms which had a salute, their grade was there with regard to how many bullet salute. These kind of things, please have a note on the GK actually. Okay, just I am saying to you. Fine. So that is there. Then here, with reference to Indian national movement, consider the following pairs. Oh, super. This and all separately can be taken and asked a question. 2019, not very far off time. 2019 asked a question. Who headed what and all, always to be seen. In that spectrum, Rajiv, here book last pages will be there. GK book it would be there. Please have a look at them all. Okay, this is what is the answer. Anybody? Sir, many name first time hearing, sir. All are correct. Okay. All are correct in this. Okay. Fine. So that is there. All are correct. Yes, D only. This is not correct. Fine. So here, Constitution Day. See, this question already asked only, but can also have potential related to it to be asked 2023. Constitution. The Constitution Day is celebrated 26th November every year to promote constitutional values among citizens. On 26th November, the Constituent Assembly of India set up a drafting committee under chairman. Superb question. First one people will go. Second one, what is the problem? And what? See how they are asking. Something I am saying, they may ask, this and all. Before they would have asked if we would not have even thought, why will they ask like this and all? Such a question, second statement. One is correct, 2 is wrong. Why? When was it? August. It was in August, yes, see. Correct, Deepali, others. So, 29th August 1947. Drafting committee. 29th August 1947. But again, little bit of thought, we would have easily understood that. Little bit of thought. But again, we should see how they are asking. So, who was the provincial president? Okay, correct, Deepali. Who was the provincial president of Constituent Assembly before Dr. Rajendra Prasad? When it came up, who was he? Where was Raja? He would be happy, but he was not. They made him Governor General because of that only. So, Sachidanand Sinha. Okay, fine. CR was the only Governor General. Okay. So, with reference to India, Rakshit, fine. With reference to India, consider the following statements. Citizenship, with regard to the recent one amendment relating to 2019, amendment relating to overseas Indian, I will have a separate question I am having. So now, this 2021 question. What is the answer? There is only one citizenship and one domicile. A citizenship by birth only can have, one can become head of state. A foreigner once granted citizenship cannot be deprived of it under any circumstance. Given statement, how many are wrong, how many are right? Huh? One only. 2, 3 are in India. Who can become citizen? Anybody who is an Indian citizen can become citizen. There is nothing like Vardhan. Correct only. Vardhana. Okay. So with case of India, this second statement, citizenship by birth is not there. Okay, that is there. That is what in America it is there already. And here, foreigner once granted the citizenship cannot be deprived. Can be deprived if you have got it fraudulently. In this, as if you see, this is okay, fine. See here, his citizenship can be terminated. See, a foreigner who has earlier granted it can be deprived of his citizenship. The points I have put in book, renunciation, deprivation, then what? Termination. That will be there. You see the points. He has abstained citizenship by fraud. He can be deprived. Disloyalty to constitution of paternal court will decide. Unlawfully traded or communicated with enemy during a war. His citizenship can be taken away. Has within 5 years of becoming naturalized, was imprisoned in any country for 2 years, has been ordinarily resident out of India for 7 years continuously. All this, a person who foreigner becoming Indian can be deprived. Understood or not? Notes I have given, once read it. This part, when I read, I had a feeling something from here they may pick and ask. Okay. Which of the following right against exploitation? A straight. Huh? Right against exploitation. Deepali, that is correct. Citizenship correct. Nayak. C. Okay. So, right again. 23, 24. 23, 24. Okay. Then which one of the following is correct? Basic concept item. Make it fast. Here. Nayak, Rajeshwari, all C, correct. C only. Rights or claims against the state or not? In context of India, which one of the following is correct relating to rights and duty? Even yesterday or day before to some class I was saying this. What is the answer? When yesterday I was saying rights are correlative to duties. A father who did not care for their children when they are young forfeits his duty. Forfeits his right we expect from the children. Duty, right? They are correlative. Yes, Adarsh Kavya. All. Okay, fine. Main features of rule of law. Numerous times asked question. Main features of rule of law. Option. First thing, what is the most important thing should come to your mind? Limitation of power. Second thing, equality before law. Because the word rule of law is not there in Indian constitution. What we have is, my dear, equality before law. Equality before law is actually called rule of law. With regard to rule of law, here, 1 to 4 answer correct only. Limitation of power, equality before law. Most important is these two. But option 1 and 2 not there. So here liberty and civil rights also become part of it. Now please learn that. That's it. This is also part of it. Right to privacy. What is it? Last 5 years 6 times asked. Sorry, 3 times asked. 21. C, correct. Position of right to property in India. NCRT, straight. Legal right available to any person. Foreigner can buy land in India. They cannot buy only agricultural land, plantation. They can buy land in India. So property right, foreigner also has. Understood? So what is the answer? B. Legislation which confers. Superb question. But these kind of question only people have to think. Apurva B correct only. Here listen. This is not B. Earlier question here. This question and all that 2021 4 years back. Some students when even first time reading, I thought immediately I thought that, but okay, after reading we got to know 32. But answer is what? 14. If a legislation is made which gives more power to the executive, listen very carefully. Legislation made by legislature. Legislature is making a law. It gives more power to the executive. To that power, arbitrary power. You can do anything you want. Such a power. It is said to violate what? Out of the given. It is Article 14. Got it or not? Article 14. Arbitrary power. Cannot be there. Article 14. Understood or not? Absence of arbitrary power. Three conditions of rule of law. Made you right. Professor A.V. Dicey's three conditions. Supremacy of constitution or absence of arbitrary power. Right or not? Question taken from there. Okay. Surendra, correct. Writ of prohibition. We will come to other things also when we discuss writ of prohibition. Straight, what is there? Others say. The prohibition means what? The upper court prohibiting the lower court. Stop. You don't, because you don't have jurisdiction to take that case. Or you are going against natural justice. Or you are going against. So you stop from proceeding in it. Forbidding to proceed. Prohibiting. That is prohibition. Certiorari is what? Prohibition available against judicial, quasi-judicial. Certiorari, executive also. Where not asking the court which is running a case to stop or quashing its order that you don't have jurisdiction or against natural justice. It can take that case to itself and here or can transfer it to the appropriate court. Anything can be done. Even against executive decision, it is available. Certiorari. Which one of the following is the nicest and appropriate relationship between rights and liberty? This is right from what Professor Lasky said they have taken. For this you are saying answer? What is the answer? C. Okay. So without right, there cannot be liberty. Professor Lasky straight statement asked. See which year? This is okay. Practice I have put to it seems. Okay, fine. So here, fine. In India, which one of the following constitutional amendments through which the right to property was removed from fundamental right and placed it as a constitutional right? My dear, why jumping? Again you are going reverse. 44. 44th Amendment Act 1978 took right to property. 31, Article 31 was taken away and kept. What is happening? 44th Amendment. Why suddenly too much we are seeing? And that is what I told. It is revision. You should be ready for it. This is what we, then only we will cover everything. You have a lot. After this, immediately I will go with current. Then we will go to convention. That is the idea. We have to cover a lot. Anyway, I will be sending whatever you are seeing here, I will send it. Okay. But I want you to read here and online, everyone. Okay. Otherwise, that is the idea here. And again, sharpen your mind. Be active. If you are this much like you are thinking here, and again, whatever we have seen, only we are touching. For that, this much thing is convention. So very fast I am going. Current at least I can little bit stay. Why are you thinking this much for this items? Okay. Now, rule of law. Tell me. Which of the above statement? Rule of law. No one is above law. Very good, Rajeshwari, very good. No one above law. No one is exempted from the law. No one can grant exemption to the application of law. Got it or not? So normally the word means that. So that is what it normally means. See, okay. Fine. Here. A person shall be convicted of any offence except for violation of law in force at the time of commission of the act charged as offence. Article 20. I have put like this. No person shall be convicted of an offence except for the violation of the law in force at the time of commission. Article 20, class 1. Ex post facto law. Is it correct or wrong? Correct or wrong? Here no person shall be subjected to a penalty greater than that which might have been inflicted on the child under the law in force at the time of the commission of the offence. This is which article? Same article. Subclass 20, class 2. Double jeopardy. Okay. So both are there. Fine. Good. Both are correct. Very good. Very good. Here. Which one of the following schedules of the Constitution contains anti-defection law? Now we are going to take schedules. Now we are going to take schedules. Schedules for full run we are going to go. Okay. Okay. 10th, which amendment brought it? See, which schedule? 10th schedule is anti-defection law. Okay. Fine. With regard to 10th schedule, if you see here, 50 yeah, Surendra, Amendment Act is 52nd. Okay. So, with regard to this 10th schedule, if you see, 1 minute. So, anti-defection law, question with regard to anti-defection law has also come. Question with regard to anti-defection law has also come. So here if you see with regard to anti-defection law, so the very purpose, political, this ethics in politics, going down and down, people switching over as they like, so get elected in one party symbol, leaving it, so they brought it. So disqualification, resigning from one's party. If less than 2/3 of the members split away from a party, less than 2/3 of the members split away from a party, then they disobey a third line whip. What is whip? What is third line whip? I am going to discuss that. Question is there. I will discuss. So third line whip is disobeyed. Listen carefully. Whip means official spokesperson of a party in the assembly or parliament. So disobeying that, then a nominated member, joining a political party after how many months? 6 months. After 6 months. Independent member, after getting elected independent, joining a political party. All this invite what? All this invite disqualification. Here the disqualification is decided by speaker or chairman. So this is with regard to it. So keep it in mind. Again also we will see which one of the following statement correctly describes fourth schedule of the Constitution. Yeah. Say another only 1 or 2 is there. Array, easy one. D, schedule 4. Schedule 4 says about which article explanation is schedule 4. Tell me that first. Which article explanation is schedule? Array, article 4 as well as article 80, clause 2. Take it, take. Take the D correct. Kavya correct. Deepali correct. Okay, here. Below it you see which article is there. It is an explanation to article 4 and 80 clause 2. So that is there. It is an explanation to article 80 clause 2 and 4. Schedule 4. Okay. So that is there. Then if a new state of the Indian Union is to be created, which one of the following schedules of the Constitution be amended? 2001. First one will be amended. Got it or not? Actually, even fourth one will be there, but here option not there. First will be amended. First schedule is an explanation to which article? Article 1 and 4. Very good. Okay. Article 1 and 4. Okay. Good. Very good, Nayak. Okay, fine. Then, 9th schedule of the Constitution of India was added by first amendment at which article? Explanation to 31B. 31B. 31B in please come on, come active, become active. Very good, Rajesh, very good. Online they are very good. Fine. 31B, seen it. 31B's explanation is schedule 9. Okay. Which one of the following schedules of the Constitution lists the names of states and specifies its territories? See how many questions they have asked. You see, 2001, 2003, just 1 year gap, same answer. First schedule, same they are asking. How schedules, many times we will think what are they asked. If you see how many times they have, all are from past year's paper only I am asking. All are from past year's paper. So here, yes, correct there. Arun correct only. Okay, fine. Rajeshwari correct. Fine. Which of the following statements correctly describes the fourth schedule? Here also you see fourth schedule alone how many times asked? Again 2004 asked. Then which of the following subjects is under the union list? This question even last year asked. So related to this. So which of the following subject is under union list in the 7th schedule of the Constitution? Which is under union list? Very good. Okay, A. Agriculture, fishery, public health, state list. Okay, little bit think in these kind of questions and all, little bit think whether any state government has brought schemes in it. State government regulates in it. Likewise, little bit think. Then you will easily arrive at the answer. Okay, regulation of labor, safety, and this one. Okay, yes, yeah, correct, Rajeshwari. Which schedule of the Constitution of India contains special provision for the administration and control of scheduled areas? Out of this is 5th schedule. Explanation to which article? 244 class 1. 5th schedule 244 class 1. Okay. 5th schedule 244. Guru Prasad, correct. 244 class 1. 6th schedule 244 class 2. 6th schedule 244 class 2. Okay. So that is there. Now, which one of the following schedules of the Constitution of India contains provisions regarding, and again question 2014. 10-year gap they have asked again. Which one? 10th schedule. Provisions of 5th schedule and 6th schedule of Constitution are made in order. Schedule tribe, very straight. So schedule tribe, about that also separately I will explain anyway. So here, Parliament. Yeah, correct. Here, consider the following statements. Parliament can place a particular law in the 9th schedule of the Constitution. The validity of law placed cannot be examined in court and no judgment can be made on it. 2018 question. People were a little confused. But what is the answer? What is the answer? Apurva, one only. Is it correct? Why? Second, what's the problem? Okay, which case? IR Koil Ho versus State of Tamil Nadu, 2007. Typical, latest was that. Even before that it was said. Right from Kashwananda Bharati to Vaman Rao case, all notes it is there, complete there, 9th schedule notes I have given. Okay, IR, very good, Nayak. So that is there. Fine. Under which schedule of the Constitution of India can transfer of tribal land to private properties for mining be declared null and void? 5th schedule. Okay, done. Very good. So 2019 question, straight one only. Okay, Rakshit, correct. Fine. Anti-defection law, consider the following. The law specifies a nominated legislator cannot join any political party within 6 months of being appointed to the house. Why false? Within 6 months he can join. After 6 months he cannot. Okay, false. The law does not provide any time frame within which presiding officer has to decide on defection. True. I think court, we are waiting for court to interfere here also. Like with regard to reserving the bill for president assent, now court has said 3 months. You have to decide. Likewise, they should say for this also, that within 2 months, 1 month, likewise you should decide. Okay. B. 2 only. Correct. Okay, correct, Apurva, all correct. Here, if a particular area is brought under 5th schedule of the Constitution, which one of the following statement best reflects the consequence of it? Okay, same question. Recent times also, little more past they asked, now again asked. Again asked. Yeah, okay. A is correct. So governor can make regulation for peace and good government of scheduled area and consulting. Listen, I have put this statement because this itself can be asked. So I have put this. See, the governor can make regulation for peace and good government of scheduled area after consulting the tribes advisory council, because 5th schedule tribal advisory council, 6th schedule autonomous councils, autonomous district council, then autonomous region, autonomous district council. Such regulations may prohibit or restrict sale, trade to non-tribal members or among. This one, regulate allotment. This one, please keep it in mind. The criteria for declaring 5th scheduled area. This is not in this one. But generally, what are all the criteria to declare 5th scheduled area? This criteria is not stated in Constitution. We are following the 1935 Act, based on which 1935 Act divided, partially excluded, fully excluded kind of a thing. Based on it, we are doing this. This question, in the name of practice, few questions I would have put. Explanations I would have put. Please read. Expecting, so we are doing it. Okay, fine. So here, what is the answer to this? Let me see. Deepali. Okay. Why this D is the answer? Why only 3 you have put? I don't know. D is the answer. Okay. See here. With regard to 244, this is there. Here, So criteria declaring preponderance of tribal population, compactness, reasonableness of size. So here, that is there. With regard to this, consider the following pairs with wait a minute. All four, that is what Deepali, all four. Okay, for learning experience only it has been put. Even I have put, see here. This explanation also I have put, okay. These criteria are not spelt in the constitution, but have become well established. They embody principles followed in declaring excluded, partially excluded areas under Government of India Act 1935. Schedule B of the recommendations of excluded, partially excluded areas, Subcommittee of Constituent Assembly, and Scheduled Areas, Scheduled Tribe Commission 1961. 1961 Scheduled Tribe Commission, UN Deber Commission. One Deber Commission. So that also kept this as criteria. So these criteria, keep it in mind. Names also important those. Okay, fine then. Okay, Deepali, fine. Consider the following pairs. Okay, so it is all that is there. So we have put this is a little current, but not current actually, a little applied matter. Tell me, like this, if a question is put, this may be to confuse you while reading. Oh, what suddenly in that case, what they have said. Very calmly read it, then you will get an answer. That is what PAL. PAL itself is what? B. Very good. Then National Commission for Minorities. See, Aligarh Muslim University again. Now mentioned as in current affair matter, I have put that also. That would be there. So National Commission for Minority is a constitutional body. Is it a constitutional body? No. It is a statutory one. Then Union government initially notified Muslim, Christian, Sikh, Buddhist, Jain as this one. So here B is correct. In which Apurva? B means you are saying only two. Okay. B means answer. Okay. This is wrong. So only two means this one not correct. Which are all not correct. Okay. So this is wrong. So this is right or wrong? This is wrong. Why? So what happened was later in 2014 Parsis were included. Jains were included in 2014. Parsis were there before. Okay. National Commission for Minorities is set up to safeguard and protect the interest of minority. Got it or not? Sorry. Here the not should not. Okay. I'm sorry. The question and this one mixed. So no. What not means? Two. Here only one. Oh, this I will correct it while sending it to you. Answer has to be not means. So two. This one is wrong. This is wrong. This is alone right. Got it or not? So only one is sorry. Not correct means two. Only one is right. This is right. Okay, we will alter that one. Not a problem. This is right. This is okay. Wrong. Okay, fine. Here. Waqf Act. With regard to Waqf Act, separate slides I have given also. Listen to me first. Before getting into it, listen to me. Waqf is singular. Awqaf is plural. Waqf means singularly a person donating. A waqf means a person giving as charity for religious purpose or helping anything. Awqaf means a collection of such property. It is plural. Okay. Waqf property means according to Islamic law, people giving for public purposes, for the benefit of the public, particularly the Muslim community. They give property, they give money, whatever it is. So this Waqf thing, right from the start, when kings were there, any king. It is not about Muslim king, Hindu king or any king. They used to give to all community. The community would have it and they will run it as trust. Like this village, you can get the revenue, likewise they will give. So that is Waqf normally speaking. In 1954, we had a Waqf Act, which is repealed by 1995 Act, which is the very important cornerstone of Waqf related items even today. This Act mandated establishment of State Waqf Councils Board to maintain, take a survey, maintain, manage the Waqf properties of that state. A central Waqf board also to be instituted to manage these state boards. In Waqf, according to Islamic principles, given court verdict, once a Waqf is always a Waqf. You given it to Waqf means you cannot retrieve it back. The charity given, you can't take it back. So that is there with regard to Waqf. The Waqf properties normally cannot be sold or transferred. It can be made use of. It cannot be sold or transferred, but there are certain provision with relating to that. That is little complex, leave it. Waqf tribunals are established to ascertain the issues relating to it. With this now, see what is the answer here. So once the property declared Waqf, status is irrevocable, cannot be changed. Said or not? The Waqf Act strictly prohibits the sale, gift, exchange or mortgage of Waqf property. Each state in India is required to establish a Waqf board. Okay, custodian of all Waqf properties. All the three statements, correct? And I have given with regard to Waqf all that relating to the Waqf, this one. See here, with this I have stopped now. The recent one, it is in court. I don't think so they are going to ask. 2025 amendment to this act has been passed. But before that, 2013 act was also passed. Where the 2013 act stated, even in another one thing I have to say. 1995 act itself had it. Waqf by user. There are two kinds of Waqf. One is Waqf by deed. Another Waqf by user. Waqf by deed means a person through deed give his property to his deed. He gives transfers for charitable purpose. That is Waqf by deed. Waqf by user means 400 years, 300 years, 200 years, some king might have given. That property and all doesn't have any record. But people are praying there, using it as some religious place, religious endowment, they are running it, using it. That is called Waqf by user. Okay. In 2013 amendment, what it stated was, whichever the Waqf board says is final. 2025 amendment stated was, and earlier in Waqf board, the 1995 Act said to set up Waqf board. Earlier in Waqf board, predominantly Muslims should be there. In fact, it was Muslim community completely many a times. But now predominantly can be there. What is the amendment which the court has asked? Then the recent amendment said Waqf by user cannot be there. But there are lot of issues with relating to it, which court said if Waqf by user is taken away, ancient, like for example, they asked the question, what will happen to the Jama Masjid of Delhi? Shahjahan's daughter Jahan Ara built it. So 300 years, where will be deed and all? Old property. So it is Waqf by user. So these kind of issues they have raised. And now court has asked the status quo to continue, how the earlier it was. Now in the present amendment they have also said, earlier there was Waqf tribunal. Now what the present amendment said was, any dispute with regard to whether a land is a Waqf land or not, the district collector may decide. So this is the issue with relating to it. So but that is now put at stay. So generally about Waqf this is there. Now foreigners tribunal. Foreigner tribunal, past few years it is there in news. The Bru tribe, Tripura, Mizoram, that time it was there in news. In Assam, NRC matter, it was in news. Even now it is in news. So with regard to, they are quasi-judicial, yes, tribunal quasi-judicial. Then the tribunal is required to solve the case within 60 days. Apurva, Sadhana, Rajeshwari, YA, no. Both, okay. Both, Kavya, both are correct, okay. So here if you see, I have given, started in 64, Assam illegal migrant. So a person alleged to be a foreigner, within 10 days of he receiving, he has to, so foreign tribunal has to dispose it within 60 days. Is it there or not? So these things I have put. So now we have dealt most convention, and this convention of schedules we have done, little bit of fundamental rights, more of the early items we have done. Now what we will be starting is that we will be starting now with this. There are other things also, but before that, what I planned, so 10 questions of this to start. Then I will go back with the other one. Where is Zoom? 10 current affair material, we will take it now. Yeah. So here, just 10 questions. Later we will take further more. So we will take a question. So, how many of you want to break it? See, nobody is raising. He told me yesterday itself, sir, you will not give break, no, sir. He told me yesterday itself. Okay. What do you see there? Online, shall we have break? Shall we have break? Nobody says anything. I have no problem. No, okay. For the mostly it is no. Okay, fine then. Fine. Divya, okay, fine. Okay, we can. Okay. See, 10 minutes, let's have a break. And it's now 11:30. Why? See, I'm saying, other than that, I won't bother 10, 15, 20 minutes, no bother agent. But now, 10 to 15 maximum, come back. 1:15 I will leave, then we can have a break for an hour and then hour or little more and then we can start. Let us cover as much as possible. Let us cover as much. Now 10 questions of current I will take. This will take little more time now. Little more time it will take. Then we will go back to the convention part, cover something, then come back. Okay, afternoon little more current also we will cover. Likewise we will do it. Okay, let us make sure that every topic is touched at least. Notes I will be sending entirely. The notes should be so exhaustive, so full. Explanations I have given completely. You need to study. That's the most important thing. Got it? Fine then. Thank you all. Let us have a break. Okay, Deepali, let us have a break. Fine, Apurva. Let's start actually. So here, slowly, let's start. See, with this question about Special Marriage Act 1954. So here, with regard to Special Marriage Act 1954, recent judgments have come where they challenged this filing notice. So, within what period notice shall be filed? So, what answer has to be given? That was filed actually before. That means, see, normally, Special Marriage Acts, people who are interreligious, without converting also they can marry. people of same religion, they can marry. So this is one secular form of marriage that is there. A person who wishes to marry should approach the marriage registrar of the district, any of the district where in past 30 days they have lived, and they should give them the details of them and whom they want to marry. Then there will be a discussion that takes place based on that. They will post a 30-day notice. Anybody wants to give objection. So right from 2015-16, even very lately, people have been saying the notice period is very wrong. So 30-day notice invites people to identify them, to harass them. So that should not be there, has been spoken a lot. But in reality, if we see, we happen to see that the court has also not agreed on it. It has accepted the filing period to be there. So in this case, right in 2006, court said, reiterated Lata Singh case verdict in 2018 Safin Jahan case. Right to marry a person of one's choice, right to marry itself is a fundamental right under 21. Lata Singh case also it is said. Now based on what I said, in this what could be the answer? Based on what I said, what is the answer? 1 and 2 only. A. Okay, yes. So here, very good. There. A, very good. That is very good. So here, A is the answer here. So if you see with regard to this, so A is the answer. So 1 and 2 only. So here the 30-day notice period is still active only. And if you see here, Special Marriage Act, I have given the objective, applicability, the procedure for it. Okay, procedure for doing a marriage under Special Marriage Act I have given. Maybe useful for some. Maybe useful for some. Fine. So objections to marriage can be there. So privacy issue. So the cases relating to it. Under Safin Jahan also you can add. But Safin Jahan case was not with the Special Marriage Act. So this is there. Actually now, quote lot of what to say, with regard to amendments demanding for changes in Special Marriage Act was filed. The last one was they wanted to include male, female kind of a thing to change as spouse, where LGBTQ may also have same-sex marriage. But that was not allowed. The court said, court denied. Court said it is matter of legislature. You go and ask that to legislature, not to us. So this was stated actually. Now listen to me here. Consider the following statements. Article 14 guarantees equality before the law and equal protection of law to all persons. This question I have put because with regard to here I have also explained. This I have put in order to explain. Karnataka government also sometime stated that in local, this one, within jobs, private sector jobs also within Karnataka, as a criteria. Reserved, 75% reserved for locals. Haryana, Andhra Pradesh, Madhya Pradesh earlier did it. Can that be done? Also, we have to discuss only included here, verdict relating to it also. So, in this generally guarantees equality before law, equal protection of law. Correct or not? Article 15 allows the state to make special provisions for women, children, and socially, educationally backward class of citizens. Right or wrong? Correct. 16 provides for absolute equality of opportunity in matters of public employment without any exception. What are the exceptions? Creamy layer. That is not directly stated there. For Tarun, I'm not hearing. No, that is okay. But here under 16, I am saying. That is not under 16. Under 16. Exception what? 16.3 is exception. Residence as a criteria. So what is the answer? 1 and 2 only. So residence can be a criteria. SC, ST weaker section that is there. So Karnataka private sector overview reservation. They have given 75% this reservation. They have given. How far is it valid? Other states, Andhra, Madhya Pradesh, Jharkhand have already brought it. Can this be valid? See, constitutional status. This one, Pradeep Jain case, allow preference but not exclusion of non-domicile. So Pradeep Jain case, court stated you can give preference to domicile, but you cannot deny anyone from outside. Understood? Then SC limits total reservation to 50%. Indra Sani case already seen. Punjab and Haryana High Court 2023 struck down Haryana 75% reservation as unconstitutional. SC asked MP government to reconsider 75% domicile quota. Understood or not? Domicile quota means Karnataka even said for 15 years or 20 years Karnataka said that they have to be individuals born in Karnataka are residing for at least 15 years. They should be having jobs. Okay, so this I have put, you read it. I will send it to you, you read it. Okay, then consider the following in respect of right to be forgotten. Listen to me, they are also online too. Right to be forgotten. Nayak residence, fine. So here if you see, right to be forgotten, the right to be forgotten is explicitly mentioned in the constitution. False. The Digital Personal Data Protection Act 2023 recognizes the right to eraser. True or not? What is the answer? D. No, Deepali, 2 is right. Last year, even I expected the Digital Personal Data Protection Act 2023 and I have said this. Okay, 2 is right. There you find eraser. Okay. So even in the notes last time I have said that would be there. So this digital data protection do say that right to be forgotten what it is. So in what context it is there. So here no specific law in India, judicial recognition in Puttaswamy case under right to privacy. This is under right to privacy. Puttaswamy, Justice Puttaswamy case is also called as what? What case name is called what? Aadhaar case. Aadhaar case. Okay. This here. So, yeah, Aadhaar. Good. So, IT rules. Though it is there, but clarity is missing even now. So, judicial precedents which relate to this right, that is very much there. So, here, consider the following. Article 324 of Indian Constitution. Election Commission, separately, current affair material I have given also. Apart from it, here I have put it because in Election Commission selection rule they have tweaked. So, Article 324 of Indian Constitution here empowers the Election Commission of India to conduct elections for President, Vice President, Parliament, state legislatures. Correct or wrong? Who conduct election for MLC, State Legislative Council? Election Commission of India. Okay. The Representation of People's Act 1950 governs the conduct of election, including election campaign. What is it? Nothing is there. Some correct. Which one, Deepali? That is first one correct. Representation of People's Act. What about this? So Representation of People's Act 19 governs elections, including election campaign, electoral dispute. Is it correct or wrong? There are two acts. Representation of People's Act 1950, 1951. 1950 Act says about who are in election, who are officers who are to be involved in conduct of election. Got it? And who are the people who are to be involved in that is whose responsibility is what? Ascertaining responsibility and to say how an election is conducted. Disputes with regard to election, qualification, disqualification, all are stated under 1951 Act. So this is wrong. So this is wrong. Okay. So that is there. Then the Delimitation Act 2002 ensures that each parliamentary constituency has equal number of votes. Why? What is the criteria? More or less the population is equal to every constituency. Equal population idea not there. Okay. So what is the answer? Okay. So this is so B. Okay, only one is the correct one. Now you can see Election Commission, their role, whatever they have to do and all. Representation of People's Act 1950. The primary thing what is there? 1951. What all they can do, this all has been stated here. Okay. So now Delimitation Commission. I have even made you write while teaching before. Gerrymandering. What is gerrymandering? Gerrymandering. Gerrymandering. You have written gerrymandering. Delimiting in favor of the party in fraudulent delimitation is gerrymandering. I've seen this. Fraudulent way of delimitation is gerrymandering. Okay, so that is there. Then Delimitation Commission, this you see. Other important provisions. Model Code of Conduct 1968. Again, if you see here with regard to this. So delimited by people. Yeah, Divya. Okay. So again here, Model Code of Conduct. About that also I have given. Model Code of Conduct. See here, right from 1968, we are started experimenting it. And now, I think 62 for the first time in Kerala, automatically they themselves brought it. 68 onwards, we are having it. Now it is very important. See, Model Code of Conduct, when it comes into existence, this is a very potential question. Model Code of Conduct, when it comes into implementation. Here, schedule announcement. Announcement of schedule can be a very potential question every year expected. And announcement of schedule by Election Commission. When schedule is announced, that time this becomes an important one. Okay, that again keep it in mind. Then these are related to VVPAT. First used in 2013, 2017 it was used in Nagaland again. Then slowly start 2019 onwards everywhere used. Then Right to Information Act 2005. Right to Information Act 2005 also aids with regard to free and legal elections. Free and legal elections. Okay. So that is there. Then here, consider the following statements. Preventive detention law allows the state to detain individuals without trial to prevent anticipated unlawful activity. Unlawful Activity Prevention Act. Things have, little change were brought. Even current affair I have given. Anyway, see here. Preventive detention allows the state to detain individuals without trial to prevent anticipated unlawful activity. But it must strictly adhere to the constitutional and statutory safeguards. Under Article 22, Clause 3 of the Constitution, Indian Constitution, individuals detained under preventive detention laws are entitled to the same protection of those arrested under ordinary law. Is it correct or wrong? 22 Class 3, online what? Anybody saying anything? Is that correct or wrong? 22 Class 3, enemy alien, one exception. Then people arrested under preventive detention, another exception. There, I have said it. Okay. So, those three are exception. So, here, if you see only one, this is correct. Okay, sorry, that is correct. This is wrong. Understood or not? So, that is there. So, here if you see, why did I put this case now? So, here, why did I put this case? Supreme Court ruling on preventive detention. Murtaza Hussain Chowdhury versus State of Nagaland. So, reaffirmed the strict standards required for preventive detention, emphasizing it is a draconian measure that was adhered to constitutional and statutory norms. What Supreme Court has ruled in it, I have put it. Case law also important. Where in this case only, court has reiterated, stated that to this state government shall adhere to what? Shall adhere to, state government shall adhere to constitutional and statutory provision. Preventive detention does not mean you do whatever you want. It shall even adhere to certain provisions. Okay. So all this I have given. With regard to it, please have a note. See, whenever unlawful, here if you see, keys related to preventive detention, National Security Act, then Unlawful Activities Prevention Act 1961, if you see, that is there. Then Public Safety Act. So on grounds of public order. Now listen to me. These are all actually added. Preventive detention, when all it can be happen. Case laws relating to it. Recent case law. See, the detention orders must be passed by a relevant material, cogent and relevant material. Jasila Shaji versus Union of India, the court held that the detainees must get a fair opportunity to challenge the detention. All I have given, I will send us notes also, current cases also. Now listen to me. With regard to Article 22, anybody who is detained shall be presented before a judicial magistrate within 24 hours of their arrest, excluding time taken for travel. Excluding time taken for travel. That is there. Apart from that, they shall be informed of their grounds of their arrest, why they are arrested. They shall be given the earliest chance to represent themselves. So these all are there, which are all again important. Which are all again important. Keep it in mind. So 22 class 3 is exception. This all is not there for who? Person arrested under preventive detention, as well as a person who is a person arrested under preventive detention, as well as enemy alien. Yes, very good. Enemy alien. But 22 class 4 to 7 says A person who is arrested under preventive detention shall within maximum of 3 months shall within maximum of 3 months be produced before judicial magistrate within maximum of 3 months be produced before advisory board, extremely sorry, not magistrate, advisory board, maximum 3 months. The advisory board should give sanctions for them to proceed. If not, it won't take place, it won't happen. So there shall be 3 months. Okay. There are some cases where they can arrest and need not take them to tribal, advisory board. Okay. So advisory board, they need not take. For them, how much time will they be inside? The law based on which they are arrested shall specify time within which, or the time for which they shall be there. Understood or not? Getting it or not? So keep this in mind. That is important. Keep this in mind. Okay, so these are all there. So then significance of this case, all I have put it here, fine. Now, with reference to emergency declared in 1975, consider the following. What was the date? 50 years of emergency. What was the date on which emergency declared? 25th June 2025. 1975. 25th June. Why? That day only the government called as Constitution Killing Day. Hatya Divas. Okay, Samvidhan Hatya Divas. Likewise, that was the day, because on 25th June it was passed. It came. So here it was imposed under Article 356 due to, see, emergency in 1970. Listen carefully about this question. Emergency in 1975. It was imposed under 356 of the Constitution due to failure of constitutional machinery. Is that statement correct or wrong? Why false? Why correct? Here also you can say. False. Why? It was passed in the name of internal disturbance, not 356, 352. Okay, so that is there. Then fundamental rights under Article 20 and 21 were also suspended during this emergency. Were also suspended during this emergency. Was it right or wrong? Fundamental rights under Article 20 and 21 were also suspended during this. Falsa. 20 and 21 cannot be suspended. Came from when? Falsa. Why all saying false? Vardhana, Magesh, Deepali, 2. 44th Amendment Act only made 20 and 20. This is 1975. Understood or not? So, then 44th Constitution, this is the after effect, made it mandatory for parliamentary approval within 1 month for the imposition of. Is it right or wrong? 44th Amendment Act. Before that, 2 months was there. Okay. Now I will be saying this anyway. Okay. So here, this, if you see, incorrect, correct. Got it or not? Now listen to me now. See, emergency 25th June. Now listen to me. With regard to emergency, what all we have to see? Maybe afternoon, few other questions on emergency I will take. Listen. Important points. Emergency, if you see, earlier 2 months has to be there. Why emergency can be invoked? Emergency can be invoked on the basis of war, external aggression or internal disturbance earlier. 44th Amendment Act made it as armed rebellion. So if it is invoked, within 2 months it has to be approved by a simple majority. Now it is special majority and again within 1 month. Earlier once approved, it goes on forever. Now within 6 months after that it has to be reapproved. Any number of time, but it has to be reapproved. Now, then it can be now revoked by Lok Sabha. So all these are changes that are there. Understood or not? So keep that in mind. So with regard to this, the certain questions relating to it all I have put. We will discuss a few things later. See, 2024 marks the 50th year of this emergency. So Samvidhan Hatiyas, Hatiya Divas, likewise they have announced. With reference to 104th Constitutional Amendment Act 2009, consider the following statements. 104 related to extending the what to say, reservation for SC, ST for further with 10 years. So it all started from 8th Amendment Act. All I have put. It will be very, very important also. All I have put, it would be again important also. Keep it in mind. So here, this 104, the amendment abolished the reservation of seats for Anglo-Indians in the Lok Sabha and State Assembly. Is it correct or wrong? 104th Amendment Act 2019, has it abolished or not? Anglo-Indians it has abolished. Understood or not? Only for SC, ST it has extended. It has extended till 2040. No, 2030. So in this, what is right, what is wrong? 1 is right, 2 is wrong. Okay. So 1 is right, 2 is wrong. So here, yeah, Varsha, A is 1 only. Yes. So 1 only if you see here, this is there. In this, if you see, I have given see here. I have given this. I am expecting also 8th Constitution Amendment, 23rd, 45th, 60th, all 10 years extension. They all amended 33, 10 years extension. Understood or not? So 10-year extension is there with relate to this. Okay, so that is there. So here 104th Constitution Amendment Act 2019. So reasons for abolishing, that is again given here. So demand for the Anglo-Indian community is demanding that we are very less in number. We can't have any representatives. So please give us it again and things like that. Okay. Now consider the following statements regarding privilege committee. Privilege committee. Privilege committee in Rajya Sabha it is there separately. Lok Sabha it is there separately. Rajya Sabha 10 members. Lok Sabha 15 members. And privilege committee means what, with regard to any of the respect of the house is denied, taken away, can be looked in by the house. So that is what the privilege committee will look into. Now tell me, what is the answer to this? Can privilege committee, actually a case, why did I put this? A case was there, P.V. Narasimha Rao case in 1998. 2024, I think last year or this year, Sita Soran case I have given. Sita Soran case, 1998 judgment was challenged. In 1998, what said? It said was P.V. Narasimha Rao was given exception that under parliamentary privilege. A is correct. Why? Rajya Sabha consists 10, no. Lok Sabha 15. No. Okay. This one also no. Okay. So A wrong. Nayak correct. Deepali D. D is correct. Okay. So here if you see, listen carefully. So in Sita Soran case, court reiterate this overruled its earlier judgment. Why it was in news? Why was it in news? So here it overruled the Narasimha Rao judgment and said, bribery and all you will not have privilege. For bribery and all you will not have privilege. You can't have privilege for bribery. So that was stated. So overturning the 1998 judgment, Sita Soran versus Union of India 2024 judgment. Important one. Okay. And what court has said with regard to that, okay, that we have stated. Bribery and all, there is no privilege. One cannot expect privilege. Consider the following statement regarding impeachment of judges in India. Judges impeachment. Before that, judges impeachment, any house it can be moved, 100 in case of Lok Sabha, 50 in case of Rajya Sabha, shall give it in writing. Even after that, the speaker or chairman may agree or may not agree. If they agree, they can admit it. After admitting, under Judges Enquiry Act 1968, a 3-member committee would be set up to investigate the charge. Then found guilty, he or she can be removed. For what reason? Not that word corruption or proved misbehavior, misconduct. Okay, they can be removed. Understood or not? So that is there. So, but that is not explained and all. Special majority. Not less than 2/3 of the members present and voting, and with more than the majority of the total membership of the house, then moves to the next house. Same way passed without inquiry and all. First house inquiry. Then it goes to president. Finally, he signs the removal. Up till date in India, it has never happened. Up till date in India, it has never happened. Now, look at this 9. So, what is the answer now? Tell me. Huh? A motion for removal of Supreme Court judge in either house retaining the support of at least one is correct or not? Grounds of removal as per constitution include corruption, abuse of power, moral misconduct. Is it there? False. The removal of judge requires special majority in both the houses parliamentary. Huh? Okay, then what is the answer? B is the answer here. So B is the answer here. Fine, 1 and 3. Correct, Kavya Dipalihal. Okay, that is the, so keep this in mind. So this is there. All I have put. In India, the failed cases. Soumitra Sen case also recently we were not able to again take that off. Remove him. Okay, now Public Accounts Committee. So Public Accounts Committee, if you see here, it is one of the very important committee. In fact, this committee is a conscience keeper of the constitution as the KAG reports. This committee, Estimates Committee, Public Accounts Committee and Public Undertaking Committee are the 3 financial committees. In that, this is the oldest committee. Right from 1921. This Public Accounts Committee is usually headed by opposition, consists of 22 persons, 15 from Lok Sabha, 7 from Rajya Sabha, and usually the Lok Sabha member is the chairman of it. Usually, Lok Sabha member is the chairman of it. Public Accounts Committee reports are advisory in nature. It looks into all the reports of the KAG. So, now you say, what is the answer? Option 1 and 3. Option D, 1 and 3. So here two, chairperson of member of Rajya Sabha. Yes, wrong. The recommendation made binding. Wrong. Okay, fine. So 1 and 3. Got it? So that is there. Then I have put in why it is in news means recently regulatory body SEBI, it is taking issue up. So conduct a performance review of regulatory bodies like SEBI, reinforcing its role in ensuring financial accountability in governance. So about Public Accounts Committee, mother of all parliamentary committee, all this part it is there. And if you see here, the chairperson, all this it is there. 1 year period they are elected, they are again rotated time and again. Key functions of it. See, public accounts estimate and this one, all this I have put. Understood or not? So this is there. Please have a note. Estimates committee also chairman only Lok Sabha. Public accounts committee also chairman only Lok Sabha. So see, now we will stop with this. We will take now this matter. Little bit of convention matter, then come back here. Little bit of conventional matter we will handle, and then we will get back into this one. Actually, we have a lot. Anyway, notes. Let us not waste time also just by class alone. I will anyway send notes to you. So that is not a problem. Tell 2002 inclusion of this one. What to establish what? Social and economic democracy. Okay. Take part. So okay, fine. Now, which of the following articles of DPSP? Promotion of international peace and security. 51. So all are the 4 points should be there. Yes, yes. Here, what is the answer? Fundamental rights from A is what? 5. Then DPSP from Ireland. Okay. A is 3. B is 5. A3, B5. Then C is concurrent list in union state relation. Where? India as a union of states with greater powers to the union where? D is what? Are there? Okay, A3, C is 1 concurrent list. Got it or not? Here this is Canada. Canada always keep in mind idea of federalism with a strong center. Canada. Idea of federalism with a strong center. Canada. Then which of the following? Vardhana, why B and all you have put there? It is straight only D. Which of the following is included in directive principles? Okay. Which one? First one is what? The first one is directive principles or fundamental rights. Which article? Second one. Which article? This is which article? 47. Yes. Except for medicinal purpose. Only 2. Okay, fine. With reference to consideration, consider the following. If you see here, this is simple actually. But you, that time, current like matter, okay. See, National Social Assistance Program launched by government. It would be fulfilled with any one of the provision. The same words are there in something here. Which is the answer? Same words. This is a program, forget it. Providing public assistance in cases of where it is. Made you underline. Public assistance in cases of old age, sickness. Directive principles. 41. What you have underlined, you have written. Undeserved want. Okay. Unemployment, all you have written. Okay. So here, under the Constitution of India, which are the following fundamental duty, not a fundamental duty, not a fundamental duty. Make it for scientific temper, duty or not. H, I think. To safeguard public property. To vote in public election. Yeah. To protect property, abjure violence, it is there. 51A, my dear. Public election, because Sardar Swaran Singh wanted to make it a fundamental duty. They didn't make it. Okay, this is what? Yes, direct answer. Why is it so? Okay, so direct answer actually. So here if you see, to safeguard public property and abjure violence, is it there or not? I told verbatim read. Consider the following provisions under direct DPSP as enshrined in the Constitution of India. Gandhian principle. Now coming. Gandhian principle are what? Article 40. Panchayat Raj, Gandhian principle. 43, cottage industry, Gandhian principle. 46, SC/ST welfare, Gandhian principle. Alcohol prohibition, 47, Gandhian principle. 48, cow slaughter, against cow slaughter, Gandhian principle. These are all Gandhian principle. In this, what is the answer? So one is not. Similarly, 4 is this one. So here if you see, which of the above are Gandhian that are reflected in the directive principles here. So 2, 3. Got it or not? Straight. Okay, fine. Correct. Correct, everyone. Which of the following provision of the Constitution of India have a bearing on education? Very important one. Actually, in that time, a lot of people made mistakes there. It was little better, little more confusing. People thought like, everything will be there or not. 5th schedule, particularly under 6th schedule, education rights is also given. Okay. So, directive principles, education anyway there. Anyway there. Then rural, urban, local body, Panchayat, 29 subjects and 18 subjects, 243G, 243W, you can see that it will be there. Okay. So, 5th schedule, 6th schedule, all there. So, keep that in mind. Okay. So, all are correct. This. Okay. In the notes, I have given everything. Have a reading of it. So, here, look at this question. Which of the following among fundamental duties laid down in the Indian Constitution? To protect weaker sections from social injustice. There are what? So what is the answer? C. C, correct. Then according to the Constitution of India, which of the following is fundamental in the governance of the country? 37 article. The provisions of this part are non-justifiable. Nevertheless, they are fundamental in the governance of the state. C, DPSP. Yes, C is the answer. Arpita, yes. Ajeshwari, Deepali, yes, yes. Apurva, yes, yes, correct. In the Constitution of India, promotion of international peace, already seen now only. To uphold and protect sovereignty, unity and integrity was stated, made in what? Preamble. Fundamental duty, D. Arpita, D. Correct. Direct. Why, if sovereignty, why are you going to preamble? To constitute India into sovereign, secular, socialist, secular, democratic republic. But to uphold the integrity, sovereignty is there in this one only. Okay. So, idea of welfare state. Idea of welfare state is DPSP. And consider the following statements regarding directive principles. Consider the following statements regarding directive principles. The principles spell out socio-economic democracy. Provisions contained in this principle are not enforceable. Okay. Now, fine. Both 1 and 2. Correct. All are. Sambhavi, correct. So, which of the following true about this fundamental duty? Fundamental. Okay, here what is the answer? Legislative process. Which of the following statements are true about fundamental? The legislative process has been provided to enforce these duties. Is there anything provided to enforce? No. So what is it, right or wrong? They are correlative with legal duties. Correlative with legal duties. What are you are misunderstanding with rights, I suppose. D is the answer, neither. How will they be? This is what this is. You are confusing. This is this. Both are same. Both are same. Why are you confusing? Both are same action. Okay. Fine. So this, keep it in mind. So that is there. Which principle among the following was added to the DPSP by the 42nd Amendment Act? Now, before getting into it, 42nd Amendment Act in DPSP added what? Article 39, clause F, not A. 39A added. 39 clause F. Then 39A. 39A clause F is for upliftment of women, children. Children care. 39 class F. Then it 39A. 39A. Then what did it do? (39A). Then 43A. 48A. All brought by 42nd Amendment Act. 43A, workers can take part in the management. 48A, wildlife protection. Okay, so that is there. In this 42nd, what is the answer? Participation of workers in management, 43A. There or not? So what will be the answer? B. Okay. B. Now consider the following statements. Yeah, B. Everyone correct. Consider the following statements. A good one. See, with reference to the Constitution of India, the directive principles constitute limitations upon legislative function, executive function. D. Very good. Okay. So What did I do? D. Okay. A very good one. Please keep note of it. Such a good one. 2017 asked. Here, with reference to the Constitution, with the part of which part of the Constitution of India declares ideal of welfare state? Article 38. KPSC state. With reference to the provisions contained in Part 4 of the Constitution of India, which of the following statement is correct? They shall be enforceable by courts. Can they be? They shall not be enforceable by any court. The principles right on this part are to influence the making of laws by the state. What is right? 2 and 3. 2 are correct, you are saying. Yes, D. Other than fundamental right, which of the following of this reflects the principles? Okay. Under the Indian Constitution, concentration of wealth violates. Superb question. Under it, wealth violates. Article 39, Clause B. Clause C. B. DPSP. Got it? Then tell me, with reference to National Legal Services Authority, consider the following. Judiciary I have taken to few, I have not here who are there, but many the online here and all I have taken. So National Legal Services Authority Act passed 1987, Legal Services Authority Act. In that National Legal Service Authority at union level, State Legal Service Authority at the state level, and District Legal Service Authority at the district level, Taluk Legal Service Authority at the Taluk level, Central Union level, headed by Chief Justice of India. He is the pattern in chief. Second in line is secretary to him, that next to him. Same way in High Court, District Court and Taluk Sub-Judge Court. They take care of legal service, that is providing free legal aid. They take care of conducting lok adalat. So all these are there. So in this now again, National Service Authority can regulate down. Likewise, now tell me, its objective is to provide free and competent legal services to the weaker sections of society on the basis of equal opportunity. Correct or wrong? Its objective is to provide free and competent legal service to weaker sections of society. It issues guidelines to State Legal Service Authority to implement the legal program and schemes. Right or wrong? I told now only it has superintendent power. So what is the answer here? Then legal services, following type of persons. Okay, see in this, even recently also I have said this. Transgender, they have allowed actually. For transgender it is there. OBC and all not there actually. Okay. So what it would be? One and why? I told transgender it is there. That means how? So A1 and 2, you see here. Who are all the members? I am sending this to you. Read it. From the section itself, I have putting it. So Legal Service Authority, I will send this to you. Please read it. Okay. So member of scheduled caste, scheduled tribe. Then if you see victim of trafficking of human beings, so women or a child, mentally ill or otherwise disabled person under circumstances of undeserved want, industrial workman. So these things, so mentally ill patients, so person who is annual income. Okay, so these are all there. I am giving it, I am sending it to you. Please read it. Asked question. In a particular scenario, Apurva found her male colleague earning more than, okay, read it. This is a practice one. What will be the answer to it? Just to say. Which article? Here, answer is DPSP. Okay. Which article in DPSP? Tell me. Directly which article? 39 clause D. Equal pay for equal work. Okay. 39. Not B. D. Not B. D. Guru Prasad. No. 39 D. Equal pay for equal work. Okay. So here we will take the next one. Parliament and Union. See, now Parliament and Union we will continue, and mostly we will try to finish this. After this, we can have a break. By around 2:30 or 2:40, we will gather. Then some current affairs we will do, and then we will do some convention, then little current affairs. So how much ever we can finish, we will finish. Rest I will be sending it to you. As I told to you, see, I could have restricted the number of questions I discuss with you. Easily I would have done it. In fact, that is good also for me too, but I don't want to do, because if you are with the question, the explanation is very exhaustively given. Try to put everything into it. Apart from it, 2 slides of at least some 40 topics, 40 to 50 topics of current matter, I would be giving it to you. That also I will send it. Whoever are going to write this time, whatever I am sending now with regard to polity, already you would have read. So that alone revise, I don't think so. Anything more than that in question is bound to come. We are going to cover everything. Okay. So those things you read, that would be enough. Now, see, 97 question. Actually, 90s question in these areas were so good. 97 question. The president shall not be a member of either house of the parliament. Can be a member or not. Then second one, parliament shall consist of president and 2 houses. Which one? What is the answer? D. Only 2. Which article? Which article says president is part of parliament? 79. 79. Okay, article 79 says so. Okay, D. 70. Very good. Very good, very good. Yeah. Now, in this, if you see, the amendment to the Constitution of India can be initiated by simple state. Constitution amendment can be initiated. What is the answer? Can we initiate by president? Can it be initiated in state? Then Lok Sabha, Rajya Sabha. So what is the only? Yeah. What is it? D. 1 and 2. Then here, this one only I still remember. Not this one, not this one. Another one question. Okay, tell me here. 54 election to president, 75 prime minister, 155 appointment of governor, 164 state council, chief minister. So what is the answer? Which one of the following amendment of the Constitution empowers the president to send back any matter for reconsideration for Council of Ministers? Article 73, 74. 40? Fourth Amendment Act. Online, why not replying? 44th Amendment Act. D. Okay. Now, under which article of Indian Constitution did President make a reference to Supreme Court asking advice on a particular matter? 143. Very good. When we speak about Article 143 advisory jurisdiction, when we speak about 143 advisory jurisdiction, in what matter should the Supreme Court mandatorily give advice? Pre-constitutional treaty. Pre-constitutional treaty, mandatorily it should give. Original jurisdiction of Supreme Court. When the court cannot have original jurisdiction even if it is between center and state or state and state. If anything related to pre-constitutional treaty. Relating to pre-constitutional treaty, they cannot have. Understood or not? So, that is there. Now, listen to me here. Which one of the following article of Indian Constitution provides that it shall be the duty of Union to protect every state against external aggression, internal disturbance? This question only, yes, I remember. People saying to me, no, they have given it wrongly. It should be 356. Why? 356 state we are saying, but it is 355. Got it? Now, in this, what is the answer? According to the Constitution of India, it is the duty of the President of India to cause to be laid before the Parliament. Which are correct? Recommendation of Union Finance Commission. Report of Public Accounts Committee. Comptroller General. National Commission for Scheduled Caste. Tell me what is wrong in it? One? Public Accounts Committee, it will not come. Got it or not? Okay, that is there. Whom and all in notes I have given. Now I am giving it. Your only job is to read it. Okay, this is there. I will be sending it. Here you see. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. If such an amendment seeks to make changes in the federal structure, the amendment also requires to be ratified by the legislature of all states of India. Correct or wrong? Then what should it come in second one? Guru Prasad, what are you putting C for this? This what is the answer? No, that's fine. Tell me. Option D, neither one nor two. Both Rajeshwari, correct. Deepa, all correct. Okay, D, why? By at least half of the states. Not less than half of the state. Constitution Amendment Bill can be presented in both the houses. Okay. The Parliament of India acquires the power to legislate in any item of the state list in the national interest if a resolution is passed to that effect. What? Article 249. What majority? Special how? Half, Deepali, that half, okay. This question. D, Rajya Sabha by a majority, not less than, very good, not less than 2/3. Whenever 2/3 comes, always read not less than 2/3. Okay, Constitution Amendment. Online here, everyone, I am saying, yesterday also some class I would have said, somewhere I saw this question, superb question, but again, to that deep we should not go, but they are, okay, no problem, listen. Constitution Amendment Bill can be moved in both the houses. When it is moved, whether to admit a Constitution Amendment Bill or not, simple majority. To admit a Constitution Bill, simple majority. Passing it, special majority. admit a constitution amendment bill, simple majority. Passing it, special majority. Likewise, for any bill, if there is a vote whether to admit it, it is simple majority only. Understood or not? It is simple majority only. To vote, it is special majority. So always be clear while reading. Okay, not less than 2/3. Okay, done. D. Okay, fine. Now, which of the following statements is here? The motion to impeach a judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act. I told her not. 150, he can reject. So that is not. So here, the Constitution of India defines and gives details of what constitutes incapacity and proved. Does it define? No. The details of the process of impeachment of judges of Supreme Court of India are given in Judges Inquiry Act 1968. Details of the process of impeachment there, no? If the motion of impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by a majority of total membership of the house and by not less than two-thirds of total members of that house present and voting. Correct or wrong? Then what is the answer? 3 and 4. Yeah. 3 and 4. C is the. Okay. Now, parliamentary system of government is one in which Rajeshwari says B. Government is responsible to the parliament and can be removed by it. Is anybody having any difference of opinion? It is good one, but a straight one. Though not directly stated, the Council of Ministers headed by PM are collectively responsible to the lower house, 75 class 3. Okay, that is that. Then see here, these kind of questions all have come. This was again another one X. 1995. 90s and all, lot of X questions have come. Okay, see here. What is the answer? At that time it is, leave it. Here now the numbers have changed actually. So there would be, but it is easy only. Not more than 530 in case of states, plus not more than 2 nominated Anglo-Indians and plus not 20 representatives of Union Territory. C. Got it or not? It was that time. Okay, maximum is 20 representatives can be there. As of today, no 2. 550 members can be there. In that 20 can be maximum for the Union Territory. Okay, even today. This one, what is the answer? Who among the following have the right to vote in the election of both Lok Sabha and Rajya Sabha? Think and answer. Lok Sabha and Rajya Sabha. Elected members of lower house of the parliament. Okay. Can they vote for? Yeah, this one. Right to vote in the elections of both Lok Sabha, Rajya Sabha. Rajya Sabha election. Can MP vote? First A. No. So that is not there. Rajya Sabha election, who can vote? MLAs can vote in Rajya Sabha. Elected MLAs can vote. Okay, elected members of lower house. D. Okay. Then, which one of the following is part of Electoral College of President but not the forum for his impeachment? Simple. MLAs vote in President. Do MLAs vote for his impeachment? No. Then State Legislative Assembly. D. Kavya Rajeshwari, all correct. Yes, Guru Prasad. Which one of the following statements about duties of Prime Minister is correct? Duties of Prime Minister is correct. Apurva D is last one, I think, not this one, I think. So here he has full discretion to choose. He can choose on his own or not. Yes, correct. If the Prime Minister of India belonged to the upper house of the Parliament, what? See, Mr. Manmohan Singh belonged to upper house. He can take part in the proceedings in lower house. Even in always he can sit there, but vote where he can do? Only in the upper house. That is what it says. So he can make statements only in the upper house. Understood or not? Just keep it in mind. Then that is, he will not be able to vote in favor in the event of a no confidence vote. Understood? Then in the presidential election in India, every elected member of the Legislative Assembly of State shall have, okay, leave this. This is actually general question, leave this, but I will have, this is a very, now changes are there, but generally even today, vote is done with what census? 71, take it that much, enough. Okay, now see, excellent question. With regard to functionaries and their oath. President of India, what will come? Judges of Supreme Court, members of Parliament, Minister of Union. Okay. A is 3, B is 4. C is 2. D 1. So what are you people saying? Rajeshwari, A was A. Option C. Superb question. Don't forget, ministers will have information privy to them. Secret information. Secrecy of information. They have to maintain. Ministers have to maintain. President of India, faith and allegiance to the Constitution. Protecting the Constitution, judges. Okay. Faithful discharge of duties, members of Parliament. Okay. Then which one of the following statement about money bill is not correct? See, with regard to money bill, if you see, with regard to money bill, the special provision in 109, money bill under 110, money bill is introduced under article 110 after the recommendation of the president. It can be introduced only in Lok Sabha. Any item from article 110 clause A to G constitute money bill. Primarily putting money inside consolidated fund, taking money outside of it, all are money bill. And appropriation from consolidated fund, money bill. So these are all there. These all are there. So with regard to money bill, if you see, more than this, with regard to money bill, the speaker should sign it as money bill. If not, it is not a money bill. Understood or not? So money bill, Rajya Sabha at best has 14 days to discuss the bill. Then it goes to the president. President may what? He shall agree or he shall use absolute veto, pocket veto, but not suspensive veto. This is money bill. Money bill is a kind of financial bill. Okay, got it or not? But financial bills are far wider than money bill. Money bill is a kind of financial bill. Now tell to me, money bill can be tabled in either house of parliament. Not correct or not? First statement itself not correct or not? Only in Lok Sabha. Okay, so this is wrong. So the Speaker of Lok Sabha is the final authority to decide whether a bill is money bill or not. Is it correct or not? The Rajya Sabha must return the bill 14 days. Correct or not? Decide now. President cannot return a money bill for consideration. Suspension to no. The answer is A. The Speaker can ask a member of the House to stop speaking and let another super question. The phenomena is known as yielding the floor. This I have discussed before, I think. That is yielding the floor. What does interpellation mean? What does interpellation mean? Mean formal right of the parliament to submit formal question. Okay. So, formal question with relate to the question to the government. That itself can be a separate question. Don't forget it. Got it or not? I think I have even discussed this with you. Consider the following with regard to this statement about Attorney General of India. He is appointed by President. Is it correct? Huh? Yeah. Then he, same qualification, Judge of Supreme Court. Yes. He must be a member of either House of Parliament. He can be removed by impeachment of Parliament. Oh, then what is the answer? Yeah, yes, all are right. Who fixes the salary of Attorney General? I made you underline. President. President fixes. President fixes. Okay, another opinion I am asking you. See, yes, we are taking. Now another 10-15 minutes I will leave. After like around 2:30 if we start, can we do it online? All are ready? Can we do it online? I'm saying. Can we do it online? Because after break, going, coming, if you are feeling tired, I'm asking that. Can we do it online? Then I will do it online. No problem. I have no problem. Okay. So morning we did it offline. Afternoon we can do it online. We can start soon. That is what actually. We can end also. So that would be there. Then fine. Okay. Here. Okay, Apurva. Fine. So here. Superb question. Primary function of Finance Commission. Superb question. Option C. Array there, online. Superb question. C. Why? Take 280. It starts with, it is, if you take 280, it will start with. Primary function is to advise. Advise on matters relating to distribution of revenue. Understood or not? So advise. So it has that one. So that is very important. The Parliament can make any law for the whole any part of India for implementing international treaty without the consent of state. Which article? Which article? For some of you yesterday even I did that. Others also. Which article this one? 23. 253. Article 253. Without the consent of any state. Okay. Yes, Rajeshwari, 253. Yes, Guru Prasad. Here. Order of Presidents. I have even told to you numerous times. Order of Presidents, please have a look at it. No point of time you can excuse yourself. So order of Presidents, please take care of it. Okay. So order of, what is the answer to this? Just at least guess it. 4. Okay. So 4, 3, 2, 1. Got it or not? So that is there. In what way is Indian Parliament exercise control over the administration? Answer. Straight answer. There. This answer. Others. Parliamentary committees. Yes, through parliamentary committees. With reference to Indian polity, which one of the following statement is correct? So planning commission is accountable to the parliament. Was it? President can make ordinance only when either of the two houses are not in session. The minimum age prescribed for appointment of a judge, 40. National NDC is constituted of union. Anyway, that is not, the answer is already arrived. Which is correct? B. Yeah. B is correct. Now, the term of Lok Sabha can be extended or cannot be extended. Can be extended during emergency 1 year at a term. Can be extended during emergency 1 year at a term. Understood or not? So can be extended by 1 year at a time. So that is there. Keep it. See, okay. Now, which one of the following is correct? Only Rajya Sabha and not Lok Sabha can have nominated member. Today, today it is correct. It was in 2003 not correct. Okay, so leave that. There is a constitutional provision nominating 2 members of Anglo-Indian community. Okay, so of Anglo-Indian community to Rajya Sabha. False. There is no constitutional bar for a nominated member to be appointed as a minister. There is no constitutional bar. Correct. Nominated member can vote both in presidential and vice presidential election. No. False. C correct. Yes, Guru Prasad told. Okay. Fine. So this one, another 2 questions we will see. A and C correct. Avia. No. Only C. The joint sitting, here she is saying, joint sitting of 2 houses of parliament is sanctioned under 108. Correct. Correct or not? The bills which are to be passed or not is in 107, 108. Correct. First joint sitting of Lok Sabha, Rajya Sabha held in 1961. Correct. Dowry prohibition bill. Second was bank reorganization, bank repeal. Bank, this act repeal bill. Third was quota 2000. Then the second sitting was held to pass bank service repeal bill. Okay, here what is the answer? Let me see. 1 and 3. Why 1 and 3? It is D 1, 2, 3. D 1, 2, 3. Which one of the following bill must be passed by each house of the parliament? Constitution. D answer here. Straight one. So what we can do is that, yeah, this item we have to take, parliament we have to take little more only. We will be anyway taking also parliament more. D. Yes, Kavya, all correct. Arpita. So we have to take little more also. So not only this, let it be there. Current matter what 10 question I took and 10 and another 3, 4 I took. So another 10 we will take when we start online itself. Wherever you are, you can join there. You have that scan, this one, no. You can join there. So what we can do, I will take. So what? After that, we will get into the current matter or the convention matter. Then little current. Likewise, we will move through. We will touch upon every topic. And again, most important, I am fast. In fact, it has to be this way. So what we can do is that, see, actually what I thought was, online, if I'm having my lab before me, I can be little more faster. Or little more, the Y means turning here and coming back will not be helpful. So this is primarily a revision class only. People who have already studied only it is. Okay, so we have to cover more. So we can get, I will take an online mode also. So 2:30 to 2:40, 2:40 around we will join. So then we will be having, okay, more. Okay, 2:30, you take it as 2:30, mostly 2:30. Fine. So we can have till 30 we have done. Okay. So rest, whatever important I will be saying. Current affair material also again I will send to you. Okay. There are enough, this one, see here, why I am saying again and again, and there is no point in then saying things actually. Because when we are giving means, I expect you people to study. You see here. So enough number of questions are there. Unlawful association. So here, this Kerala filing case against. Here we will be seeing centers borrowing power of center and state. Then election commission related appointment. That in between also we will see. In question also I have put that all are there. So numerous items is there. So what you should do, you shall study. That is your part. Okay? Done then. Fine. So with this we will conclude this morning session. Afternoon around 2:30 we will restart online. Is it okay? Fine. Thank you all. Okay.
So morning, we happen to see certain this questions, past year's questions, along with it, certain questions we did discuss, and current affairs also. This we can discuss here. With regard to this, here, so yeah, good afternoon, good afternoon. Can't see video. Yeah, Shubha, I will on. Yeah, that is there. I have switched it on. 1 minute. Let me open now. So I told to you from where we left the current affair matter. That current affairs matter, little bit we will be handling, I said. So 10 questions we can handle from that current affair matter. So after that, we can go for some convention part, finishing this parliament related one. And those things we will be seeing. Then after that, we will again take little bit of current affair matter. So that would be better. This is what we decided morning, that accordingly we will handle. So public accounts committee, till that we have done. So consider the party whip. Okay, just 1 minute. Just 1 minute, 1 minute. So here, this So, morning while teaching some other aspect also, I did say to you that this whip. So here there is a question before you all with regard to the concept of whip. So, the party whip is explicitly mentioned in the Constitution of India and is legally binding on all MPs, MLAs. So here, people, whoever want to participate, please participate. That your answer with relate to this answer also. So here, voice is not clear. Now it will be clear, Apurva. Now I suppose it will be clear. So you can take part in this answer also, like they. So here, if you see, with regard to party whip. So the concept of a party whip is explicitly mentioned in the Constitution of India and is legally binding on all MPs and MLAs. So all MPs and MLAs, if you see here, Apurva, even voice is not clear. Okay, I'm not understanding anything this. So the first one, it is the Constitution of India does not define. First of all, what is a whip? So here, if you see here with regard to whip, if you see, whip is nothing but this official recognition of a person who is an MP or MLA in either parliament or in state assembly, who actually will say the party stand. Whatever he says with regard to the party stand is the final one, and that is the official party stand. So here what the thing is, the whip will be saying that whether a particular decision taken by the party has to be adhered. There are three kinds of whip: one line whip, two line whip, three line whip. So one line whip, if you see, like they will just inform a thing, no compulsion. If you disobey also, no problem. Second whip, ask you to come. Third whip is the most important whip. The third whip is that there what they would be expecting with regard to the third whip is that here the third three-line whip. In three-line whip, it is legally binding for a person to accept the whip. They have to, it is binding and they have to agree with the decision taken by the this one. Okay. By the concept of party whip, and again the violation of three-line whip can lead to disqualification of all MP under anti-defection unless a two-third majority of the party defects. So in this statement, first statement is constitutionally mentioned and it is not constitutionally mentioned at all. So it is has no mention at all. So that again, one thing is wrong there. With regard to three-line whip, it is there. First one is wrong. So a violation of three-line whip can lead to a disqualification is correct. So again, Constitution do not define this with what I have said. What is the answer? Constitution do not define whip. Anti-defection law mentions about whip. Why does it mention a three-line whip when it is not obliged? It's a sufficient ground for disqualification. So what is the answer here? With what I have told, what is the answer? Shubha Dipali, B. 2 only, very good. 2 only is the answer, very good, very good. So this 2 only is the answer here. Got it? So if you see here with regard to this, 2 only. So here, party whips. Vice President of India recently raised concerns about party whips restricting MPs' independent judgment, sparking a debate on parliamentary democracy versus parliamentary discipline. So if you see here with regard to this, okay. So role of it, official, party official. So it is from UK that what this word has been borrowed. So 10th anti-defection law, the 10th Amendment Act do say about it. 1-line whip, 2-line whip, 3-line whip. So 1-line whip, 2-line whip, 3-line whip that are there. So with regard to 1-line whip, it is an informal notice. 2-line whip, if you see there, this mandatory attendance is there, but strict voting direction is not given. You may or you may not. That is not given actually. So, but a 3-line whip, that is important one. When violated, that won't be tolerated. They may be recommended for they to be disqualified. So that is there. Now, functions of whip, all I have put actually. So whip stifles debate. The recent why I have put this as current affair matter. Recently, the vice president here said the whips in the presence of whip is nothing but like it stifles democracy. It undermines democracy. There is no dissent and all. So Kyoto Holohan case upheld anti-defection law but cautioned against misuse of it. So it grants MP's freedom of speech, but subject to party discipline. So that is there with regard to India. The whip is there, but under anti-defection law, not under constitution. So that is there. Now, this is also like I have put with regard to it. Fine. With reference to overseas India, I told to you, the question may even come. So with refers to overseas Indian card holders, consider the following, because the 2021 amendment rules changed a part of it such a way that few overseas Indians cannot enjoy the complete right as like that of a citizen. So if you see here, if this with regard to the statement here, so see definition with regard to overseas Indian card holder. See 1955 Act Section 7A and again 2002 and 2005 they brought person of Indian origin and overseas Indian card holder system. 2015 it became one card. The name is overseas Indian card holder. Having that card, anybody who is an Indian citizen of origin, not citizen now, of origin, any of their foreparents or anyone was an Indian citizen can very well take up this one. So here if you see overseas Indian card, with regard to this overseas Indian card introduced in 2005, but 2015 onwards it is there, except citizens of Pakistan and Bangladesh, where all are persons of Indian origin. Rest all who belong to the undivided India can get this card. Active and retired foreign military personnel cannot get benefits of it. Key restrictions, no political right they cannot have, and government jobs they cannot enter into. So 2021 amendment stated OCA is treated as foreign nationals. So previously aligned as NRI. Now they are treated as foreign national, but they can come and go. Okay, got it or not? So earlier they were equal to NRI, but without the property one. Now they are treated as foreign national. That is what it is. Special permits for visiting protected area. This is what is important here. So for visiting protected area, approval needed for missionary and research activity. This change they brought it actually. Okay. So overseas Indian card holder enjoy parity with Indian citizen in all and educational matters except for purchasing this agricultural land. Then 2021 amendment to OCA rules placed them at par with foreign nationals under FEMA, requiring special permits for visiting protected areas in India. Okay, so here if you see correct is 2 only. The reason is that OCA will have parity with NRI, not Indian citizens. So keep that in mind. Now they are to be treated as foreign national when they have to visit certain areas. For example, line of permit wherever there, they shall be treated that way only. So wherever line of permit thing is there, they shall be treated that way only. So that is there. So this is what it says. So hope you have understood. Why we have taken that on also. So if you see here, total overseas 45,000 plus lakh. This one, America, how many are there? And this country wise, even that can be a question. So only this we have taken that. 1 minute, just a minute. For the stylus pen or pen means it will be easier. Okay. Okay then. Fine. Now consider the following statement regarding relaunched e-Shram portal. e-Shram 2.0. Anyone can participate also. e-Shram 2.0. Okay. Portal provides gig and platform workers with a unique ID to track their eligibility for social security benefit. Correct or wrong? Correct or wrong? Okay. That is right. The portal is directly managed by Niti Aayog. This is where the problem is. To ensure policy coordination. So what would be the answer here? Okay. So A is the answer here. Why? Very good, very good. Somebody has written. Let me. Labor, very good, Vishal. Labor Ministry. Yes, exactly. So it is Labor Ministry with regard to this, the portal managed by Union Labor Ministry, and that is very, very important. Keep that in mind. Launched and a lot of registrations on daily basis. It keeps going and. Swanidhi, PM Swanidhi, street vendors, 12 major schemes linked. Nariga and PM, PMAG, AYG, and all these things actually. So everything I have given. Gig workers means those like Swiggy, Zomato, anybody. Today, gig market is becoming more and more. Okay, so largest unorganized sector database. So slowly providing them with some kind of what to say, support actually. So that is there. So which of the following statement is are correct regarding Pradhan Mantri Mudra Yojana? Pradhan Mantri Mudra Yojana. The recently introduced Tarun Plus category under Pradhan Mantri Mudra Yojana provides loans ranging from 10 lakh to, this is Tarun Plus. There are multiple categories in Mudra Yojana. This is Tarun was there already. This is Tarun Plus. Scalable interface with a good repayment record, 10 to 20 lakh. Yes, it is correct. So loans under PMY, because Tarun was 5 to 10, provided only by public sector banks. No, it is also provided by other banks also. The scheme offers collateral-free credit and loans are covered under the Credit Guarantee Fund for microfinance. So here, one is correct, then 2 is wrong absolutely, then 3 is correct. So the answer here is D. And with regard to Mudra, as I told to you, you see Shishu. Okay, D correct, fine. So Shishu up to 50,000, Kishore 50 to 5 lakh, Tarun 5 to 10, Tarun plus 10 to 20. Please, this schemes can come. New one. So this is can come. With regard to gig economy, they can ask any question. Okay. But that gig economy related question, I am expecting in mains only. But that can come. These kind of things can come even in prelims also. Okay. So, fine. So the growth support that since 2015. And what are all the sectors? Retail, transport, food services, who are all eligible. So that is again there. Then, which of the following statement is or regarding the Swachh Bharat mission? Regarding Swachh Bharat mission, phase 2 focuses on sustaining open defecation-free status and improving solid liquid waste management in rural areas. So this is phase 2 of Swachh Bharat scheme. then aims to achieve 100% scientific solid waste management, eliminate landfill sites in all Indian cities by 2026. Anybody? Anybody? Okay. So both 1 and 2. So these kind of things. Yeah. We kept it for that reason only, both 1 and 2. Why the reason kept was Guru Prasad, good. So here kept for that reason only. So there is better learning would be there. So here Swachh Bharat 2. So 2014 to 19 was 1 and 2020 to 25. So this 100% coverage achieved, aspiring basic waste management, both solid and liquid waste management, visually clean and full waste processing, Swachh Bharat Mission 2.0. So here garbage free cities, 100% garbage waste secretion by 2026, zero landfill, 1,000 plus cities, processing 100% solid waste. Safai Mitra Suraksha. Okay, Safai Mitra Suraksha, mechanized cleaning to replace manual scavenging. This is again a scheme that is there with regard to this. Fine. So these are all that is there with regard to Swachh Bharat Ghosh. That is a fund that has been implemented with reference to the proposal for fixed tenures of legislatures. See, recently a bill was proposed, has not been passed under the ex-president, Mr. Ramnath Govind. They introduced one nation, one election commission to look into it. And they also went through it. They submitted the report. And accordingly, the Constitution Amendment Bill is also proposed. In a current affair material separately also I have given that. It proposes a fixed 5-year term of both Lok Sabha and state assemblies, preventing early dissolution. True. Under the current constitutional framework, the term of Lok Sabha and state assemblies can be extended indefinitely during national emergency. Is it indefinitely? Is it really correct to say that it is indefinitely extended? How much extended? What extension? Even the morning we saw that. How much is it extended? 1 year at a time. Correct, Deepali. 1 year at a time. Yes, Arpita. So this is wrong. So what is there? First one is right actually. So this is wrong. Okay, Shubha, correct. First one is right. Second one is wrong. What is the answer then? One only. Yes, Rajeshwari. Yes. Fine. So that keep it in mind. So in news. So the 129th Amendment Act 2024 proposes this fixed 5-year term. So currently legislatures can be dissolved yearly, leading to frequent election. So they wanted to bring an amendment and include 82A, one article called 82A. They plan to include, which not been included up till now. Okay. So about that details I have put it here. With reference to National Human Rights Commission, consider the following. They are established under the Protection of Human Rights Act 1993 in compliance with Paris principles adopted by United Nations. Absolutely correct. Chairperson of National Human Rights Council must be a serving Chief Justice of India at the time of appointment. He can be a serving Chief Justice, usually, retired Chief Justice or a Supreme Court Judge. Retired Chief Justice or a Supreme Court Judge. So second is wrong. Third, the NHRC includes ex officio members who are heads of various national commissions. National Commission for Women, National Commission for Minors, such as. So it says such as. But 6 commissions all are there, part of it. So here if you see 1 and what could be the answer? 1 and 3 exactly, correct. 1 and 3 can be, is the answer, not can be, is the answer. Okay, so that is there here. So I have put to you, so the tenure is 3 years or 70 years of age. So now recently opposition said Mr. K.M. Joseph could be, but there was an issue with relate to it. So consider the following statement regarding the appointment of chief election commissioners. and the election commissioners. Chief election commissioners and election commissioners. So as per Supreme Court 2023 ruling, the appointment of CEC and ECs was to be made by a selection committee comprising of the PM, the leader of opposition in Lok Sabha, and Chief Justice. See, 2023 Supreme Court stated for temporary time being, this should be the selection process. After that, Parliament can make a law. This was what was stated. And the Election Commission Act 2023 replaced the CJA with Union Cabinet Minister in the selection committee. Actually, the problem was the court said this should be the composition, leader of opposition, Lok Sabha head and this Chief Justice of India. But what they did was Election Commission Act 2023 replaced CJA. Yes, correct only. The tenure of CEC and ECs as per 2023 Act is 5 years or until 65 years, whichever is earlier. In this, so the thing here is 1 and 2, right? The tenure under is 6 years, not 5 years, 6 years or 65 years. Now, if you can see the so I didn't see the chat actually. Okay, A is correct, B is also correct. Only A is correct. A is correct. 1 and 2, correct. So here the third one, because 5 years, 6 years, that is only wrong. What happened was the selection committee, government, though this is blatant violation of what the court has said. Court has said that CJI, this election Prime Minister and the leader of opposition, but court has simply denied this Union Cabinet Minister. Sorry, CJI, and just to put Union Cabinet Minister, they themselves appointed also. This is a very sad reality. Already the challenge is before the court, but they haven't bothered. They have went ahead with their appointment. So that is there. So in different states, how it is, I have put. Then Article 371. See, with regard to Article 371, Mizoram recently, Meghalaya recently asked that they need protection like that of 371A of Nagaland. Reason was, listen carefully, very, very, very unique, that actually the matter was different, but the question that was framed was different. That matter was a rat hole mining. There was this mining called rat hole mining. Rat hole mining is banned now in Meghalaya because of that accident that took place. What is rat hole mining? With regard to rat hole mining, that the individual person goes deep down inside this tunnel and all, and they try to mine things. So it's a very dangerous, this one. So rat hole mining, in this rat hole mining, many people died in Meghalaya, but voice of people, one party, the people there are so poor that they need some work to do. So they want rat hole mining to start again, maybe with regulation. But Supreme Court has banned rat hole mining in not only in Meghalaya, in whole of Northeast except Nagaland. Why? Under 371A, which speaks about Nagaland, the 13th Amendment Act brought in. Nagaland, that according to 371A, the ordinary laws which are made by Parliament even cannot overpower the state approved laws. 371A. So Nagaland has that power. Now Meghalaya wants something like 371A. 371J, Hyderabad, Karnataka region. First statement correct or wrong? 371A statement correct or wrong? A is correct. Wrong. Yeah. Sorry, now only Sudamani. Wrong. Correct. So it is Nagaland, not Mizoram. Similarly, if you see here, 1 minute. Okay. Then second one is correct or right or wrong? Second one. 371J, very well known, correct. Karnataka. Then, sixth schedule provides. Now, how many districts are there within 371J? Now, how many districts are there within 371J? Though this question UPSC will not ask, but state it may be. How many districts are there within 371J? I'm asking how many districts are there in that Hyderabad Karnataka region. 6 were there, now 7 it is there. Okay, yeah, yes. Pushpanjali, Guru Prasad, 7. Okay, correct now. That is what I. Okay, fine. So here, sixth schedule provides special autonomy to tribal areas in the northeast states, including Meghalaya. Does it provide or not? Assam, Meghalaya, Mizoram, which one? Then what? The sixth schedule area, where? You see. Assam. Okay. Nayak. Okay. That. Very good. Well, no. Got it. All are answering. Good. Okay. Fine. So this is their answer we have got. That the rest you can see. Okay. So here. Superb question. With reference to the devolution index ranking of Panchayat Raj, sometimes mentioned in the news. Satish, fine, Satish. Mentioned in the news, consider the following statements. Devolution index ranks states based on the extent of decentralization and empowerment of Panchayat Raj institutions in areas such as functions, finances, functionaries. Correct. Released by Niti Aayog in collaboration with Indian Institute of Public Administration. Is that correct? That is wrong. And again, devolution index, who is number 1? Tell me soon. I'm expecting. I will put all the data, but devolution index, who is number 1? Karnataka. What you people? Karnataka number 1. With regard to first one right, second one wrong. So obviously, A is the answer here. Why wrong? Second one wrong because it is released by Union Ministry of Panchayat Raj in collaboration with IAPA. So Union Ministry of Panchayat Raj in collaboration with IAPA. Okay. So that is there. So here, Karnataka, Kerala, Tamil Nadu. Karnataka is overall number 1 in the ranking. Okay. Your people are living in Surga. Fine. Listen. Rise or not dialogue. Okay. We can take this one. Normal convention part. Then we will come back to this and this one. Take it up. So convention part we will take now. So I stopped with wait. Thirty done. So here, as per Indian protocol, who among the following ranks highest? 1 minute. Okay. This one, I think Sushma is answering here. Right. Vishal is saying governor of state, governor of a state within his state. Okay. C is the answer. Order of presidents, president, vice president, governor. Order of presidents, if you see, president, vice president, PM, governor of state, within the respective C, 4 would be, in my opinion, 4 would be governor of state, 8 would be governor of state within the state, governor of state outside the state. That would be 8. So that is again there. So keep them in mind. Here, consider the following 2003 question. In Electoral College of President, the value of vote of an elected member of a legislative assembly equals total population by elected MLAs of the state into 100. Is it right or wrong? Say suddenly, simple, straight. Is this right or wrong? Wrong. Why? It is 1 into 1000. Okay. So that is the value of vote of an elected member of this. Just 1 minute. Just a minute. Okay. Okay. So see that 2003, 5,000 member latest election and all not valid today. Value of vote of an elected member are equal to total value of votes of all elected MLAs and total number of elected MPs. That is correct one. Okay. So answer is this B. Okay. 2 only. While members of Rajya Sabha are associated with committees on public accounts and public undertakings, members of committee on estimates are drawn entirely from the Lok Sabha. Is it right or wrong? Morning also we saw. I did say this. Morning also we saw. I did say this. Is it right or wrong? Right. Okay. Correct. So 30 members. The Ministry of Parliamentary Affairs works under overall direction of the Cabinet Committee on Parliamentary Affairs. The Ministry of Parliamentary Affairs works under the overall direction of Cabinet Committee on Parliamentary Affairs. Okay. So, is it right or wrong? It's a technical question. Ministry of Parliamentary Affairs works under the overall direction of Cabinet Committee on Parliamentary Affairs. The Ministry of Parliament nominates member of Parliament to committees. Who nominates? Who nominates with regard to member of committees? Who nominates? 3 is wrong, but who nominates? I'm asking. 3 is wrong. 3 who nominates? Third statement. Speaker or chairman nominates. Speaker or chairman nominates. So A is the answer here. Okay. 1 minute. A is the answer here. So that is there. Just to. Okay. So this, with reference to the Indian Parliament, which one of the following is not correct? The thing is not correct. Okay. So the appropriation bill must be passed by both the houses of Parliament before it can be enacted. Appropriation bill is passed where? Lok Sabha only. Article 114. Appropriation bill passed in Lok Sabha only. No money shall be withdrawn from consolidated revenue except under the appropriation made by the Appropriation Act. Correct. Okay. Yeah, okay, fine. The finance bill is required for proposing new taxes, but no additional bill or act is required for making changes in the rates of tax which are already under operation. Correct. No money bill can be introduced except on the recommendation of the president. So, A is the answer here. So, it is straight one. So, with regard to this, now, the Speaker of Lok Sabha has the power to adjourn the House sine die, but on prorogation, it is only the President who can summon the House. But on prorogation, it is only the President who can summon the House. What is the first statement? The Speaker of Lok Sabha has, but on prorogation, only the President has the right to summon the House. Straight to one. Correct. This one is correct. Unless sooner dissolved or there is an extension of term, there is an automatic dissolution of Lok Sabha by the efflux of time at the end of the period of 5 years. Even if no formal order of dissolution is issued by 1, 2, 3, correct? Rajeshri. Okay. If unless sooner dissolved, there is the extension of term, there is an automatic dissolution at the end of period of 5 years. Correct. Okay. Then the Speaker of Lok Sabha continues in office even after the dissolution of the House. Okay, 1, 2, 3. So D is the answer here. Wait. Further. Which of the following is not correct? In the Lok Sabha, a no confidence motion has to set out the grounds on which it is based. In Lok Sabha, a no confidence motion has to set out the grounds on which it is based. No confidence motion is the grounds needed or not. Adjournment motion, you need the grounds. A is not correct. Correct. Absolutely, you are right. Okay, because no confidence motion, listen to me. With regard to no confidence motion, the Constitution do not mention it. It is mentioned under the rules of Lok Sabha. For a no confidence motion to be moved, 50% giving it in writing to the Speaker to move the no confidence vote. Done. There is no compulsion that where they have to move kind of the how and all. So this simple thing, it can be moved. Once moved, there is no reason to be stated. They can just a debate, then a vote. Simple majority. If passed, the ruling party has to resign. That is what it is. So first one itself wrong anyway. So that one fine. We can proceed. The resolution for removing the Vice President of India can be moved in. The resolution for removing the Vice President of India can be moved in. Rajya Sabha, Article 67, Clause B. Very good, very good. Satish, Deepali, Sushma, Guru Prasadal. Correct. Very good. 67, Clause B. Article 67, Clause B. Sorry. Okay. 1 minute. So here. So that is there. This D is answer here. Straight. with reference to the Constitution of India, which one of the following pairs is not correctly matched? Not correctly matched. Which is not, have you, see, little bit of thinking. Sir, how can we know all, sir? Little bit of thinking. Yeah, Sushma, right, B. Rajeshwari, all B, right. But how? Little bit of thinking. Stock exchange. Have we ever heard a state stock exchange? Concurrent list means at least states could have also started on their own. There is no state stock exchange and all. Stock exchanges belong to union only. So that is there. Union list it has to come. Then Waqf comes under which list? Superb. I'm asking general question. Waqf comes under which list? Say immediately. Waqf comes under which list? Waqf comes, good Shushma, state list. Entry number 28. Entry number 28. There's endowment, charity, and that what the topic would be there. Waqf comes under that. Sir, then how can union pass law in it, sir? 1995 Act they passed. Now also they are amending and all. How, sir? See, when two or more state legislatures under Article 252, under Article 252, when two or more state legislatures request the union to make a law in any of the state subjects, they can very well make a law in any of the state subjects. Understood? So that is what it is. With relate to it, so that is what it is. They can very well make Article 252. Likewise, in 1990s, several state governments asked the center to make a law in Waqf. So accordingly, in 1995, the Waqf Act was passed based on that. So that overall has a governance over many others Waqf throughout India. Article 252, yes, exactly, Arpita Apurva. Who was the first Lok Sabha speaker? Several times asked a question. G.V. Mavalankar. Okay. The chairman of Committee of Public Accounts is appointed by Speaker of Lok Sabha. The chairman of on Public Accounts is appointed by what, Apurva? The chairman of the Committee of Public Accounts is appointed by the Speaker of the Lok Sabha. The Committee on Public Accounts comprises members of Lok Sabha, members of Rajya Sabha, and a few eminent persons from industry. And the second statement is right or wrong? Yeah, one only. Yes, correct. Rajeshwari, correct. Okay, two is because other members and all cannot be there. Only elected members. Constitution of India provides that a legislative assembly of the state shall consist of not more than 450 members. Is it so? Which article? It says 500. Take Article 170. 500. Legislative Assembly maximum 500, minimum 60. But there are exceptions in case of Mizoram, Sikkim, and all. There are exceptions. Goa, Mizoram, Sikkim, there are exceptions. Here, a person shall not be qualified to be chosen to fill a seat in the Legislative Assembly of a state if she is less than 25 years of age. Is it correct or wrong? Straight, simple, straight. A person shall not be qualified to be chosen to fill a seat in the Legislative Assembly of a state if she is less than 25 years of age. Two, correct only. Yes, correct. Okay, good. Good. Others also, these kind of questions also participate. With reference to union government, consider the following statements. Constitution of India provides that all cabinet ministers shall be compulsorily be a sitting member of Lok Sabha only. Constitution of India provides that all cabinet ministers shall be compulsory. Is it right or wrong? Is it right or wrong? Nobody is answering. Is it right or wrong? First statement, wrong. Cabinet minister can be from any house, both Rajya Sabha and Lok Sabha. Union Cabinet Secretariat operates under the direction of Ministry of Parliamentary Affairs. Earlier, what we seen, they have asked it upside down. So, what is the answer for this? 44D. Neither. Earlier, we saw upside down. Ministry of Parliamentary Affairs is assisted by the Cabinet Secretariat. Now, what they have asked here? Upside down. Which is wrong. So, D is the answer here. With reference to union government, consider the following statements. The ministry and the departments of Government of India are created by the Prime Minister on the advice of Cabinet Secretary. Is it right or wrong? Asking you. The ministers and departments created by Prime Minister. No doubt. Wonderful. Wrong. Each of the ministries is assigned to a minister by the President of India on the advice of Prime Minister. This is correct or wrong? Okay. So answer would be B only. So that is what it is. Why? The Government of India Act, the rules, allocation of rules 1961, made under Article 77. So here, the Government of India are created by the President on the advice of Prime Minister under these rules. With reference to union government, consider the following statements. Number of ministries at the center. On 15th, this is one statement alone important. For that I have. Number of ministries today is different. I think 58 we are having now. But the number of ministries at the center, ministries, not ministers, ministries in 1947 was 18, correct? In 1947, one only. Rajeshwari, if you would have answered this, it is correct. Now, when the annual budget is not passed by the Lok Sabha, when the annual budget is not passed by the Lok Sabha, here the budget is modified and presented again. When the annual union budget is not passed, the union ministry is asked to resign. The union finance minister, Prime Minister submits a resignation. D, very good. Very good. D is the answer. Straight answer. The authorization for the withdrawal of funds from the Consolidated Fund of India must come from. The authorization for the withdrawal of funds from the Consolidated Fund of India must come from. Where? B, Parliament. Very good. Very good. Contingency fund come from President. Public Accounts Fund come from Executive. That is Council of Ministers headed by PM. Article 266 and Article 267 speak about it. Okay. So, contingency, consolidated and the Public Accounts Fund 266, 267 contingency fund, both for state and center. It is there. Fine. Nice, Sushma Deepali. Now, in the Parliament of India, the purpose of adjournment motion is. Purpose of adjournment motion, not adjournment. Adjournment motion is. Let us see, tell me. Yes. Very good. Apurva. Sushma, A is correct. To discuss matter of urgent importance, public importance. That is correct. Yes, Deepali. A. Consider the following statements. Union territories are not represented in Rajya Sabha. Are they represented or not represented? Tell me. They are represented. Union territories are actually represented in Rajya Sabha. So that is wrong. Delhi, Puducherry, JK. It is within the purview of Chief Election Commissioner to adjudicate. Delhi, Pondicherry, JK also. Arpita. It is within the purview of Chief Election Commissioner to adjudicate the election disputes. Adjudicating the election, Vishal has put the Pondicherry. It is according to Constitution of India, Parliament consists of Lok Sabha and Rajya Sabha only. Wrong. 3 is absolutely wrong. Then within the purview of the Chief Election Commissioner to adjudicate election disputes. See, this is a very technical question. The here answer in this is Union territory is not represented in Rajya Sabha. Actually, it is represented. So it is wrong. It is within the purview of a Chief Election Commissioner. No, not within this purview. Election disputes depends upon which dispute you have to go. Constitution of India Parliament consists of this one. So that is the answer. Okay. Here Delhi Pondicherry means the earlier one. So we have put that one. So with this, we are finishing one part of it. We will take the next one item. Wait a minute. Regarding the office of Lok Sabha Speaker, consider the following. He, she holds the office during the pleasure of the President. They hold the office during the pleasure of the President. So in fact, if you see here, with 1 minute. So, answers you have. Very good, very fast. 3 only. During pleasure of the President, no. He, she need not be a member of the House at the time of their election. They have to be. If he, she intends to resign, the letter of resignation addressed to Deputy Speaker. Only 3 is right. Only 3 is right. So the Prime Minister of India at the time of his her appointment, 2012 question. See, what is the answer? What is the answer to it? Need not necessarily be a member of one of the houses of the parliament, but must become a member of one of the houses within 6 months. Exactly. That is the right one. Got it? Fine. That is right. Yeah, straight one. 75, that last part, if you see, it will clearly state that any person can become a member provided that they shall see, anybody can become a minister provided that within 6 months they shall become member. Okay, that is there. The deadlock between Lok Sabha and Rajya Sabha calls for a joint sitting of the parliament during the passage of deadlock between Lok Sabha and Rajya Sabha calls for a joint sitting of the parliament during passage of so 108 article is applicable to which kind of law? Constitution Amendment Bill cannot have joint sitting. Money Bill cannot have joint sitting. So obviously left out is only A. Okay. So A alone, Arpita, yes, ordinary bill alone, Apurva correct, Sudamani correct. Right. What will follow if a money bill is substantially amended by Rajya Sabha? Simple. Lok Sabha may agree, may not agree, may go ahead with their old thought also. So no problem at all. May still proceed accepting or not accepting the recommendations of the Rajya Sabha. Okay. So that is just a minute, just 1 minute. The parliament can make any law for whole or any part for implementing international treaty. Already we have seen this 253. Okay. Which of the following principles are implied institutionally in the parliamentary government? See that. See that. So the answer to it is, so the members of the cabinet or the members of the parliament. So then the ministers hold office till they enjoy confidence in parliament. Cabinet is headed by the head of the state. So C is 3 is absolutely wrong, you know. Based on it, A is correct. Huh? Okay. So in this we can even go with that logic. So that is also there. But okay. A is the answer here. Down 1 minute. In the context of India, which of the following principles are implied institutionally in the parliamentary government? Which are institutionally implied in the parliamentary government? So here we have seen it. This one. So A is the answer. The Council of Ministers in the center shall be collectively responsible to the parliament. Question, listen, 2013. First statement correct or wrong? Tell me that. Wrong. Very good. Only Lok Sabha. Rajeshwari, very good. Only Lok Sabha. So see how they have asked. Not parliament, only Lok Sabha. Then the union ministers shall hold office during the pleasure of the President of India. Nayak, you can okay, you have put, you could have put, I will answer that, Nayak. You have put a question. This one I will answer to you. I will answer to you, not a problem. And let us finish this a little bit, this one, and I will come to you. It's a good question what you have asked. Even there is a current related matter to it. Fine. So here, collectively responsible, correct. Union minister shall hold office during the pleasure of the President of India. So union minister during the pleasure of the president, correct only. Then the prime minister shall communicate to the president about the proposals of the legislation. Generally under 78, he shall communicate. Okay, so that is what it is. So here 2 and 3, here they are collectively responsible only to Lok Sabha. Okay, now this question, see. Okay. I put it for all others also. One is wrong. Chairman and deputy chairman of Rajya Sabha are not the members of that house. Chairman and deputy chairman are not the members of that house. 1 minute. Okay, yeah. So the chairman and are not the members of the deputy chairman is member. Okay. While the nominated B, the nominated members of the two houses of the parliament have no voting right in the presidential election. They have right to vote in the election of vice president. So, okay, that is right actually. Hope you answered it correctly. Deepali, all correct. Okay. Then here the president shall make rules for the more convenient transaction of business of the government of India and for the allocation among ministers of the said business. President shall make rules for the convenient transaction of business of government of India and for the allocation among ministries. 77 article. So here all executive actions of the government of India shall be exercised to be taken in the name of the Prime Minister. All executive to take in the name of President. We all know it. Okay. So the answer is B. That is A. One only. Sorry. One only. The power to increase the number of judges of Supreme Court in India vested in Supreme Court, the power to increase the number of judges in the Supreme Court of India. 1 minute. He is vested in Parliament. Power to increase the number of judges in the Supreme Court of India is vested in the Parliament. Power to increase the number, increase whatever strength to determine in High Court is determined by President. High Court, it is determined by President. Keep it in mind. So, that is there. So, Parliament, High Court, Article 216, determined by President. Consider the following statement regarding no confidence motion. Already we have seen actually. So, let us move forward. Largest committee. Given there, which is the largest committee? Estimates committee has 30 members. Rest all are public accounts and public undertaking 15, 7. With regard to petitions, 10, 15. Okay. So that is what it is. Rules committee. Can anyone say what is the number of members of rules committee in Rajya Sabha? Rajya Sabha rules committee. Rajya Sabha rules committee has 16 members. Lok Sabha rules committee has 15 members. There is a qualitative difference. Okay, fine. Which are the following functions? Cabinet Secretariat. Now, go recent thing itself. 3 questions on Cabinet Secretariat we have seen. Preparation of agenda for Cabinet meetings. Yes, they are involved in preparation of agenda for Cabinet meetings. Secretarial assistance to this one. What is the answer? Tell me, someone. Nayak, wonderful. Yes, yes. Before also somebody has said. Good. So allocation of financial resources. So allocation of financial resources is done by whom? So resources to the ministries as per the provisions of the budget is the task of finance ministry. Okay. It is finance ministry. Now, with reference to the union government, consider the following statements. 2015 question. Department of Revenue. Budget who prepares? Economic affairs that is there. Who prepares? This is revenue. Do they prepare? First one itself wrong. No amount can be withdrawn from the consolidated fund without the authorization parliament. Correct or wrong? Article 110. All disbursements made by okay. 1 and 3 wrong. Okay, got it. Public accounts need the authorization of parliament. No, executive. Okay. There is a parliamentary system of government in which in India, because there is a parliamentary system of government in India because Council of Ministers responsible to Lok Sabha. Very good. Very good. Consider the following. Rajya Sabha has no power either to reject or to amend a money bill. Does it have the power to reject or amend a money bill? No power. The Rajya Sabha cannot vote on demand for grants. Yes. Rajya Sabha cannot discuss the annual financial statement. Third statement, is it right or wrong? Come on, Deepali, why are you, not Deepali, someone else said D. Sushma, why D? Can discuss, Arpita, correct. Rajya Sabha can discuss. So only is it third statement correct or wrong? See, they can discuss but cannot do anything. 14 days they can very well have discussed. Yes, Rajeshwari. 3 is wrong. Only 1 and 2. Come on, Shushma. When a bill is referred to a joint sitting of both the houses of parliament, it has to be passed by. When a bill is referred, it shall be passed by. What is the answer? A simple majority of members present and voting. Very good. Very good. Because joint sitting usually which bills? Ordinary bill only. Now, consider the following statements. The executive power of the Union of India is vested in the Prime Minister. Executive power of Union of India. Okay, the Prime Minister is ex officio chairman of Civil Service Board. D. Hope you all have seen this question before. Okay, so Cabinet Secretary is the ex officio chairperson. Execute powers vested with President. See, in between I have put the concept questions. Democracy's superior virtue lies in the fact that it calls into activity. Lies in the fact that it calls into activity what? Very good, Deepali. Very good. Intelligence and character of ordinary man. Ordinary man. That is correct. 1 minute. Okay. A is correct. A is only correct. Yes, sure. Which of the following is not necessarily the consequence of the proclamation of President's rule? Not necessarily. President's rule. Dissolution of state assembly. It is necessary. Removal of the council of ministers in the state. Dissolution of local body. So here, which is not necessary, consequence of proclamation of president's rule in the state. 1 and 3. Very good. Very good. Very good. Okay. So normally, if this option matter is not like that, they will go with it. So removal of council of ministers in the state will happen. But it will not be with regard to the assembly or dissolution of local body. Got it or not? The reason is that here not the only the government, whichever government it is there, they don't ask majority. If time of 5 years is there, the other person can be called to form the government. Opposition can even be called to form the government. Okay. So that is there. Now, look, 1 minute. Now look at it. Indian federalism. So here, with regard to this Indian, okay. 1 minute. Deepali A, D, Indian federalism. There is an independent judiciary in India, not a feature. Powers have been clearly divided between center and states. Federating units have been given unequal representation in Rajya Sabha. It is the result of an agreement among the federating units. So, which is not a feature of Indian federalism. Deepali, why are you saying A? Not a feature they are asking. Independent judiciary is certainly a feature. Not only Deepali, others were also saying. Who else? See, it is a result of agreement between federating unit. It is not at all. Absolutely, it is not. D is the answer. Why should you even think of other things? D is so straight, no. Why should you think of other things? Yes. Now, look into this. Out of the following statement, choose the one that brings out the principle underlying cabinet form of government. What underlines cabinet form of government? See. Mechanism of parliamentary democracy for ensuring collective responsibility and of the government of people. Government to the people. Okay. So, okay, fine. This is C is the answer. Almost very good. Most of you has found out. I don't think anybody have wrongly typed anything. Okay. Fine. Nayak, I think you asked no. Private member bill. Is a bill presented by a member of parliament who is not elected but only nominated by the private member bill. Is a bill presented by the member of a parliament who is not elected but only nominated. Is it correct or wrong? Private member bill. Once let us see about private member bill. Wait. See, first one is wrong. With regard to private member bill, any person who is elected member, who is not a minister, is a private member. He can be even a nominated member. So he can present a bill. Now he asked me a question, sir, elected but not minister. Arpita, I'm not getting it. Yes, exactly. Elected but not minister. I'm getting it. I understood. Correct, Arpita. Elected but not a minister. That is a private member. This private member bill, if you see, anybody who is not a minister can present it. Only thing is that, like, if a minister presents the time duration 1 month before they have to give a petition, and absolute veto can be easily used against private member bill. So if you see here, private member bill, can a private member present money bill? See here, constitutionally, you don't have any provision which says otherwise. But private member usually don't present, ministers present money bill. Because ministers only have the right to take the money out of consolidated fund or deposit in the consolidated fund. So ministers alone. So the question, the answer for what you asked is no. If they ask a question in constitution, has it ever said that private member cannot? No, that way it is not there. But answer to what you asked is no only. Okay, the private member bill has been passed in the parliament for the first time. No, wrong actually. Okay, so here the answer would be obvious. When both are wrong, it is D. Only 14 private member bill has been passed since 1952. Okay. Here. Nayak, fine Nayak. Nayak, put it for everyone. Don't put a direct message. See, when you put a message means put it for everyone. Then will be better. Personal, this without your knowledge, that setting is there, I think. So correct it. So for the election of the Lok Sabha, a nomination paper can be filed by. Election of Lok Sabha nomination paper can be filed by. One is wrong. Anyone residing in India, okay, is wrong. Okay, and any citizen of India whose name appears in the electoral roll. This is the most important one based on Representation of People's Act 1951. Okay, that is there. Simple but technical question. Now, if the election of Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. We all know it has nothing to do with any kind of reality. So it is wrong. So then, according to the provisions laid down in the Constitution, 1 minute. Let us see. Laid down in the Constitution, the Speaker's post goes to majority party. Yes, both are wrong. Both are wrong. D. One minute. Here. In the first Lok Sabha, the single largest party in the opposition was Swatantra Party. Actually, opposition as a recognition came in 1967 after. Statutory recognition came in 1977. That is what it is. And again, opposition, who is an official opposition party means who is second in number of seats in Lok Sabha along with at least 1/10 of the total seats they shall have. Okay, so 1 and 3 wrong. So leader of for the recognized for the first time. So that is there. So 1 and 3 wrong. In this, with option technique, we can easily arrive at the answer. So here, with the statement is correct means only 2 is correct. With reference to the Parliament of India, which of the following parliamentary committees scrutinize? See, by reading it, you can, the word sub rules. word sub-rules. So we can easily arrange subordinate legislation. Okay, Business Advisory Committee, again it is there. 15 members in Lok Sabha, 11 in Rajya Sabha. So Business Advisory Committee, General Purpose Committee, number of members shall be decided by the Speaker and the Chairman. General Purpose Committee, number of members shall be decided by Speaker and Chairman in their respective houses. Regarding money bill. So bill shall be deemed to be a money bill if it contains only provisions relating to imposition, remission, alteration or regulation of any tax, which is not correct. A money bill is a provision for the custody of consolidated. Let me see, anybody is answering. Money bill is concerned with the appropriation of money out of. Yes, fine. So this is the correct one. Article 110. If you see, read properly, it is very, very easy to understand. So very good, Rajeshwari, very good. With reference to election of president, the value of vote of each MLA varies from state to state. Yes, depending on their population. Value of vote of MPs of Lok Sabha is more than the value of vote of Rajya Sabha. Second statement, correct or wrong? Second statement, correct or wrong? Wrong. Very good. Because the MP's vote is all same to everyone. Spurti, yes. Yes, fine, fine, fine. This is correct. If the President of India exercises his power as provided under Article 356 of the Constitution of India in respect of a particular state, then the Assembly of a state is automatically dissolved. If the President of India exercises his power as provided under 356 of the Constitution, the Assembly of the state is automatically, wait, people are answering. B is correct answer. Let me, the power of the legislature of that state shall be exercisable by or under the authority of the parliament. The power of the legislature of the state shall be exercised. Yes, correct. Okay. So that is the 31B. Again, Parliament Prevention of Disqualification Act exempt several posts from disqualification on the grounds of office of profit. Yes, it is correct. This act only is in responsible for this office of profit and this exemptions and all with from office of profit. So keep it in mind. The above mentioned, I see what kind of questions they are asking actually. So how many times it has been amended? 1 and 2 correct, 3 is wrong. Term of office is well defined in the Constitution. It is not defined. So 3 is if you delineate. So office of profit not defined. So 3 if you take away 1 and 2, A is the answer in that way also. But that was the time this elimination technique and all they were giving. Now also any question just try to see. This is very, very, because third is the most easiest. Because second one and all everybody will have a confusion. Sir, how will I know that 2 and act, how many times they have amended and all. But yes, now you get to know. But one thing, the third statement is an important one. In India, which of the following review the independent regulators in sectors like telecommunication? See, telecommunication, insurance, electricity. So independent, review the independent regulators. So certainly committee of parliament will be involved in it. Parliamentary departmental related committee will be involved in it. Then who else would be there? This I think we have seen in class. Okay. So 1 and 2. So financial sector. But about financial sector, legislative commission was set up for a limited time period under B.N. Sri Krishna's chairmanship. It mandate did not include reviewing the electric regulator. So 4 is wrong. Similar reason eliminates finance commission, which is set up periodically as tax distribution allowed. Niti Aayog is a think tank and a policy advisor of the government. That's it. Okay. In the context of India, which one of the following is a characteristics appropriate of bureaucracy? Which is a characteristic appropriate of bureaucracy? Very good. Very good. Implementation of this. Good. Then 2020, according to the Constitution of India, a person who is eligible to vote can be made a minister in a state for. Is the statement correct or wrong? I have stressed this. Wrong. Why wrong? Because 18 years eligible to vote. They cannot become minister. 25 years is required. According to Representation of People's Act 1951, a person convicted of criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting election even after his release. So what? D. Okay, fine. So from release 6 years. From release 6 years. After that, they can contest. From release 6 years, they cannot. After that, they can. Okay. Just a minute. The President of India can summon a session of Parliament at such a place as she thinks fit. Superb question. 85. Second question first you see. Second is right or wrong, you say to me. The Constitution of India provides for 3 sessions of the Parliament in a year, but it is not mandatory to conduct. The Constitution never, first of all, says that, so it is wrong. There is no minimum number of days that the Parliament is required to meet in a year. Yes, there is no minimum number. So 2 shall not be there. 2 shall not be there. 3 shall be there. Answer would be what? So simplest thing. 1 and 3. Okay. So that is what it is. Rajya Sabha has equal powers with Lok Sabha in the above equal power in what? All India Services 312. Rajya Sabha only creates it. Removal of the government. Lok Sabha alone has the power. Making cut motion. Lok Sabha has the power. Amending the constitution. Yes. Rajya Sabha also has the power. Yes. 1 minute. Read it. A bill amending the constitution requires a prior recommendation of the President of India. Does it require amendment bill? No. When a constitution amendment bill is presented to the President of India, it is obligatory for the President of India is to give his or her assent. Now, actually, there is no obligation, but now it is there. Earlier, it was not there. Now, a constitution amendment bill doesn't have veto. So, it is deemed to be passed. The Constitution Amendment Bill must be passed by both the Lok Sabha and the Rajya Sabha by a special majority. And there is no provision for joint sitting. Correct. So here, what should be the answer? So, B 2 and 3. The 24th Amendment Act amended 368 that the Parliament has the power to amend any provision of the Constitution. The amendment further made it obligatory for the President to give his assent. When so they cannot deny. The Constitution of India classifies the ministers into 4 ranks. This classification not done by Constitution. Total number of 1 minute. The 1 minute. The total number of ministers in the union government, including Prime Minister, shall not exceed 15% of total member. Article 75 1A, 164 1A, 15% or 15 members. Sorry, or 12 members. In case of state. Union, it is 15 members. This 15%, sorry, not members, 15%. 1 minute. Just 1 minute. So, here, the Constitution of India clarifies that the minister is classified into 4 ranks. Actually, Constitution doesn't classify anything. Minister is classified into 4 ranks or not. 1 minute. So, here, the total number of ministers, union government including, yes, you are right. So, with regard to 164B, it is 15% or 12. Here it is 15%. In Article 239, AA, that is with regard to Delhi, 239A, with regard to Delhi, it is 10%, including CM. It is 10% including CM. So that is there. So 15%, 91st Amendment Act, 15% in union, 15 or 12 in state. In case of UT Delhi, 10%. In case of JK, they have stated as 10%. 10% they have stated in case of JK in State Reorganization Act. State Reorganization Act, they have stated as 10%. Puducherry, they have not stated. Actually, 20% are running just like that as convention. They are running because only 30 out of it 6 members are there. So B is the answer here. One minute. Now, which of the following is or exclusive powers of Lok Sabha? Exclusive power to ratify the declaration of emergency. See, ratifying declaration of emergency, both Lok Sabha, Rajya Sabha, to pass a motion of no confidence against, this is exclusive. To impeach the president, non-exclusive. Okay, what would be the answer? B alone. Yes, absolutely right. With reference to Deputy Speaker of Lok Sabha, consider the following statements. As per the rules of procedure and conduct of business in Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. See, Speaker only fixes. the date of deputy speaker election. There is a mandatory provision that the election of candidate as deputy speaker of Lok Sabha shall be either prince. There is no mandatory provision anywhere. 2 is absolutely wrong. The deputy speaker has the same power as that of speaker when presiding over the sitting of the house, and no appeal lies against his rulings. Correct only. He has the same power. A well-established parliamentary practice regarding the appointment of deputy speaker is that a motion is moved by the speaker and duly seconded by the prime minister. So here 1 and 3, got it or not? So 1 and 3 is correct. So rest 2 is not right. Any question? Here, if the election of the president of India is declared void by the Supreme Court of India, all acts done by him or in the performance of his duty before the date of decision becomes invalid. No, it is valid. It is valid. So the first statement is wrong. The election for the post of President of India can be postponed on the ground that some legislative assembly have been dissolved and the elections are yet to take place. Tell me, Rajeshwari, second one. Election for the post of President of India can be postponed on the ground that some legislative assemblies are dissolved. Need not be postponed at all. Jammu and Kashmir was not their last election. They need not postpone it. Okay. Then when a bill is presented to the President of India, the Constitution prescribes time limits within which time limit the Constitution does not prescribe. So here the answer is, with what I told, what is the answer? D, Nanna. 1 minute. Wait. See, if the election of President of India declared void by the Supreme Court, all the acts done by him is valid actually. Okay. So that is there. D is the answer. Fine. Got it or not? D is the answer to it. 1 minute. Water has fallen. Okay. Now, okay. So that is there. So even the explanation I have given it fully. So have a look at it. So here, this was a very tricky one. I think before year asked a question actually. So here, with regard to this, if you see, statement 1, the president is elected not directly by the people, but by members of electoral college, consisting of this first one. So higher the number of elective assembly seats, higher is the value of vote of each MLA in that state. So not at all correct actually. The elected members of legislative assemblies of the states, here. So the elected member of legislative assembly of a state shall have many votes, as many votes as there are multiples of 1,000 in the quotient obtained. So you cannot say like in a MLAs or more means more vote will be there. So for president election. So that is there. And with regard to Kerala, all these things. So the statement how 3 is wrong, 4 is correct. That is stated here. The value of vote of MLA of MP is greater than that of Kerala. Kerala may have less number of MLA, but compared to Madhya Pradesh, when the division happens with regard to total population with the number, obviously Kerala and Madhya Pradesh, if you see, the value of vote of MLA of Madhya Pradesh is not greater, in fact, lower. The value of vote of each MLA of Puducherry is higher than that of Arunachal, though in the ratio of population, no. It is other way out. Sorry, this is right. Value of vote of Puducherry is higher. That is correct. Which one of the following statement is correct as per the Constitution of India? Last year question. The state list Waqf I told for that reason only. Nowadays, very regularly they are asking questions on it. So what is the answer here? See, interstate quarantine, union subject. Yes, under union list. Yes, correct. As per Article 368 of the Constitution of India, the Parliament may amend any provision of the Constitution by way of, I have even said in class, why the reason to look into Barak. The very first 2-3 lines of Article 368 clearly mentions this. Now, 109 mentions special procedure in respect of money bills. Which of the following statements are correct in respect of money bill? 109 special procedure. Yes, correct. Money bill shall not be introduced in Council of States. Correct. Rajya Sabha can either approve bill or suggest changes but cannot reject it. Correct. Amendment to the money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha. Okay. So need not be accepted. So what is the answer? All has said. Answer is C. Okay, straight answer. Till 50 we can see here, then we can see certain current affair. Then let us see like, otherwise I will send everything, no worry. It is the governor of the state who recognizes and declares any community of that state as scheduled tribe. Is it governor or is it whom? Who has to declare it? President, very good. So the community declared as scheduled tribe in a state need not be so in another state. Is it right or wrong? B. Yes, correct. B only. Okay. With reference to union budget, the union finance minister on behalf of Prime Minister lays the annual financial statement before both the houses of parliament. C. At the union level, no demand for grant can be made except on the recommendation of President of India. Yes, correct one. Okay. This is again correct only. The union finance minister on behalf of the Prime Minister lays the annual finance. But sorry. Hey, pa, this is such a wonderful question. Why? On behalf of whom? On behalf of whom? President. Yes, Article 1112. See here, I also was carried away. I didn't see that properly. No, just like that. So on behalf of President, actually, President of India shall cause it to be laid before the Parliament. On behalf of President, he or she, they submit it actually. With reference to the Speaker of Lok Sabha, consider the following statement. While any resolution for the removal of Speaker of Lok Sabha is under consideration, she shall not preside. Can they preside or not? Normally, they should not preside. She shall not have the right to speak. They can speak actually. She shall not be entitled to vote on the resolution in the first instance. See, while any resolution of the Speaker of Lok Sabha is under consideration, he shall not preside, but he cannot vote and all. If he doesn't preside, means what is the problem actually? Okay. Why D? Ruthie, why D and all? It is simply straight no. How can you put all correct? He, she shall not have the right to speak, but they can speak. What is wrong? Okay. So with this, we will now move to current matter. There's a very few questions are there. Don't worry, very few are there. That we will finish and come back. Which of the following statement is or correct regarding Raisana dialogue recently organized? Okay, by Ministry of External Affairs and Niti Aayog, their statement, but it is correct or wrong? Tell me first statement correct or wrong? Wrong. Very good, War. Very good, Vishal. Very good, very good. Observant research. Yes, correct. Wrong. The 25th edition focused on the culture of people, peace, and planet. Second statement. Kalakchara. The dialogue is modeled under Moody's security. This third statement. Say something. What about second statement? Kalakchara is the name. Okay. It is the name. People, please, and planet. That is the name. Theme. Third one is absolutely correct. Okay. Now you see here. See, Observer Research Foundation is part of it. So, discussing weaponization of trade and economy, we saw the weaponization. Also, we have seen America putting tariff all. So, that is what the discussion was. So, Quad's concern. Then Philippines proposal was Quad alliance. So, digital sovereignty. Then modeled after Munich Security Conference. Global leaders, policymakers, India's flagship geopolitics and geoeconomics forum, with reference to Unlawful Activities Prevention Act 1967. Sometimes mentioned in the news, which of the following statement is correct? UPA allows government to designate both organizations and individuals as terrorists. Under UPA, an accused person is entitled to regular bail under normal criminal procedural law. Second statement, leave the first statement. Tell me whether second statement correct or not. Tell me second statement correct or not. Because just by hearing you can get to know. Incorrect. Very good. What about first statement? So here if you see, it is correct. The UPA enabled the government to designate individual as well as organizations. Oh, correct. Good, Rajeshwari. Okay. So as terrorist and apart from it, regular bail provision. So here designate organizations as unlawful organization, terrorist organization, historical 1967. When they added 2004, they added terrorist activities in its scope. So expanded the definition of terrorism, then economic security, all. Consider the following statement about the transition to simultaneous election. Sorry. So 82A, I already said the introduction of simultaneous election requires an amendment to the Article 82A of the Constitution. They have proposed to bring an amendment called 82A as a new section. But in 82A and all, you need not. Already we don't have 82A. The case of premature dissolution of Lok Sabha, fresh elections will be conducted for the full year. If premature dissolution happens, only the remaining year they will conduct election. The Election Commission of India will be responsible for logistical arrangements, including upgrading EVM storage for synchronized election. In this, 3 is correct. Based on what I told, whether 1 and 2 right or wrong. Here, how many of the are incorrect? How many of the above statements are incorrect? This is incorrect, this is incorrect. 2 are incorrect. Okay. 2 are incorrect. Got it or not? How many of the above statements are incorrect? Ah, good, good. So I have put before you. Consider the following statements about Constitution amendment process in India. President of India can return a Constitution amendment bill for reconsideration of the Parliament before. Can he do? Absolutely not. That is what we saw. 24th Amendment Act clearly stated Constitution amendment bill cannot be returned or anything. It shall be ascended. It shall be given assent to. Then the Constitution amendment, first one is not correct. The Constitution amendment affecting the federal structure requires ratification of at least half of the state legislature. Correct or wrong? Correct one. Let us see. The amendment made through the simple majority method are not considered Constitution amendment under 368. Yes, very good. Correct. So, B is the answer. So, I have put here also. Then, good one. Central Vigilance Commissioner and Vigilance Commissioners are appointed by the President of India on the recommendation of a committee consisting of Prime Minister, Chief Justice and Leader of Opposition in Lok Sabha. Sadhana committee brought the Central Vigilance Commission. Recommended, not brought, recommended. CVC has no power to directly prosecute individuals accused of corruption and relies on agencies like CBI, DOPT for legal action. Which how many statements are correct? Okay, so here 2 only. The reason is CVC first one and VCs are appointed by President, but the recommendation committee consists of Prime Minister, Union Home Minister, Leader of Opposition. Chief Justice is not part of this committee. Okay, so CVC has no power to directly, this can come, very well come. Just okay. With reference to State Human Rights Commission, the chairperson of State Human Rights Commission must be a retired Supreme Court judge. That SHRC has the power to investigate human rights violation by armed forces within the state. What is the answer? Okay, neither I have touched it. Okay, leave it. Neither 1 nor 2. See, it is incorrect because let me see. No, Spurti, see, answer is D. The chairperson of SHRC must be a retired Chief Justice of the or the Judge of High Court, not Supreme Court. Not the retired Supreme Court judge. Through recent amendments, proposed changes. Section 2 is incorrect. The State Human Rights Commission cannot investigate human rights violations by the armed forces. Such cases falls under the jurisdiction of National Human Rights Commission. So please have a note of this. National Human Rights Commission can challenge, question the punishment of, sorry, the chairperson of SHRC must be a retired Chief Justice. That is one. Home Ministry should be there. Then, sorry, extremely sorry. We are confusing one thing. So, chairperson, he is a retired judge, but he is not a Supreme Court, but a state one. And violation of armed forces comes under the union list, state National Human Rights Commission. Very, very simple. Sorry. The last question in this one I confused with regard to the committee for CDs. With reference to the appointment and removal of judges in India, the President appoints Supreme Court judges in consultation with Chief Justice of India and other judges of the Supreme Court. The President appoints, tell me whether correct or wrong. President appoints Supreme Court judges in consultation with the Chief Justice of India and other judges of Supreme Court. Collegium, yes, he shall. The collegium system of judicial pronouncement is explicitly mentioned in the Constitution. Is it explicitly mentioned? A collegium? Wrong. Okay, good. Very good, Nayak. The Supreme, Satish. Yes, Deepali, correct. The Supreme Court judge can be removed from office only on the grounds of proved misbehavior or incapacity through a process requiring a special majority in the parliament. Yes, that is true only. So the answer to this should be what? How many statements are this one? So only 2 statements are correct. In that, the second statement is wrong. Collegium as an idea came from where? It came from the second judge's case. Okay, second judge's case. 1 minute. Yes, B is correct. Okay, so some of the current matter we have done. Now, the traditional matter, little bit we will do. Randomly, I will pick one. Wait. Judiciary. Here, little bit we will see here. Just for some 20 minutes or something, we will see. The power of the Supreme Court of India to decide disputes between center and state falls under simple, straight. Tell me. Straight, tell me. Original view. Very good. Now, when the Chief Justice of the High Court acts in an administrative capacity, wonderful question. He is subject to superb question. When Chief Justice of the High Court acts in an administrative capacity, that means as an executive. Take it this way, he is acting as an executive. He is subject to discretion. Yes, A is correct. Deepali, why see? Last question you said or this question you said? If this question, no, I think A is correct. A is absolutely correct. Writ to jurisdiction of any other judges of High Court. Then according to Constitution of India, the term district judge shall mean, I think Article 236 would say about what shall it mean. There are a lot of names. In that shall not include, which shall not include this. So, if you see here, tribunal judge, it does not include. They made it actually easy. These all are named 236 if you see. These all are named. Other name for this district judge. Different places, different connotation. They are called by different name. Okay, that is there. Which is the answer to this? Tell me. Which is the answer to this? Willful disobedience or non-compliance of the court orders, use of derogatory language, contempt of court. Contempt of court is an outcome of Article 129 and 215 of Indian Constitution, though it is not stated in the Indian Constitution. But if you see, with regard to contempt of court, H.N. Sanyal Commission recommended it, and we brought Contempt of Court Act 1971. There is criminal contempt as well as civil contempt. Civil contempt is not performing the duties as said. Willful disobedience or non-compliance, again, civil contempt only. Criminal contempt is scandalizing the work of the court, bringing defame to the court. That is called like that. So in this, both the statements, if you see, the statement seems to be right, but what is the explanation to it? B, they are not, they are independent statement, not one asserts the other. Tell this, in this, tell the answer. B, tenders advice speak on matter of law or fact only, yes, exactly, only if he asks. There are 2001 they have asked, as of now 25 high courts are there. 3 of them have jurisdiction more than one state. No union territory has high court. Yes, Delhi has its high court on its own. Now J&K also has. Judges of high court hold office till the age of 62. Correct. So D is the answer here. 4 only. D of them. Okay. So if you see here, 25 high courts as of now we are having, and they have jurisdiction more than one state. That is, there 6 high courts have jurisdiction more than one state, not 3, 6. Okay. B. D, no. Which one? B. B is 2 and 3. How could it be? D is the answer here. Only 4. Correct. No union territory has got high court of its own. There are 3. Wrong only. 3 of them have jurisdiction. 6 of them have jurisdiction. That is again wrong. There are 18 high courts in the country. No, there are 25 now. Salaries and allowances of the judges of high court are charged to the Consolidated Fund of India High Court. I'm saying. Consolidated Fund of State. Very good. Pension charged to Consolidated Fund of India. The power to enlarge the jurisdiction of the Supreme Court with respect to any matter included in the union list of the legislative power rests with. Straight question 138. The parliament. Okay, just 1 minute. I will put this off. Listen. Done. No. So here Parliament, Article 138. Okay. Which one of the following high courts has the territorial jurisdiction over Andaman and Nicobar Islands? Simple, straight. Come on, answer. I didn't see. Sorry. Kolkata, Shushma, Nayak, Deepali, all correct. Correct. Everyone correct. Good. Now, here. So the highest criminal court of the district is the Court of District and Sessions Judge. The district judge are appointed by the governor in consultation with the highest criminal court in the district is the Court of District and Sessions Judge. Is it correct or wrong? Correct. The district judge are appointed by the governor in consultation with the High Court. District judge in consultation with High Court, correct. Every person to be eligible for appointment as a district judge should be an advocate or a pleader of 7 years standing or more, or an officer in judicial service of the union or the state. When the sessions judge awards a death sentence, it must be confirmed by the High Court. Now, tell to me what is the answer. Make it soon. It is easy. D is correct. Yes. Spurti, for everything you are saying D, but this D is correct only. Okay, this D correct only. Fine. According to National Human Rights Commission Act, who among the following can be the chairman? The retired Chief Justice or Judge of? C is the answer. Straight. Which one of the following is the correct sequence in the descending order of precedence? Warrant of president. Please say. Descending order of warrant of precedence. Please say. Plea 2. B. Others are not even thinking or what? B. Okay, even I have put actually relating to it, I have put it here. There are 25 high courts in India. Punjab, Haryana, and the Union Territory of Chandigarh have a common high court. So there are 25 as of now. 25. Last was Amravati, and here Punjab, Haryana, and Union Territory of Chandigarh have a common high court. And this Union Capital Territory of Delhi has a high court of its own. What is the answer? Apurva is saying C. Then others? C it is. Okay, fine. It is simple, easy only. C it is. Parliament cannot enlarge the jurisdiction of Supreme Court of India as its jurisdiction is limited to that conferred by the Constitution. This is statement right or wrong? Absolutely wrong. 138 we did see. The officers and servants of the Supreme Court and High Court are appointed by the concerned Chief Justice, and the administrative expenses are charged on the consolidated of a fund of India. The officers and servants of Supreme Court and High Court are appointed by the concerned Chief Justice. So, oh my God. Okay. So statement is correct. First is wrong. Here, now see. Statement is correct. In India, every state has a high court in its territory. Is it right? Just to say right or wrong. I myself am wrong. It doesn't have. So it is very simple. A is false. The Constitution of India provides for high court in each state. Yes, that is there. But it is not there. Who was the Chief Justice when public interest litigation was introduced? Tell me. I have told the name in class. Justice P.N. Bhagavati. Who was the now? Okay, fine. Who now say to me, Satish, Apurva, all fine. Now listen to me. Who was the president when emergency was invoked? Who was the president when emergency was invoked in 1975? Mr. Fakhruddin. No, not Zail Singh. Fakhruddin Ali Ahmad. He also died in office. First president to die in office. President Zakir Hussain. First president from Assam. Fakhruddin Ali Ahmad. Then first OBC president. Gyani Zail Singh. First SC president. Mr. Now. KR Narayanan. Not RK, Vishal, KR Narayanan. Okay, little change. Okay. Then ST, Mrs. Murmu. Lady, Mrs. Pratibha Patil. Okay. No. A person who has held office as a permanent judge of High Court cannot plead or act in any court or before any authority in India except Supreme Court. No. In the court where he was High Court judge and other High Courts, he cannot. Supreme Court and other High Court, in whichever High Court he was there he cannot. Other High Courts he can and Supreme Court he can. So first is wrong. Person is not qualified for appointment as a judge of High Court in India unless he has at least 5 years held judicial office in the territory of India. Why? Neither. Very good, Nayak. Very good. Okay, the reason is second one. Not only that, can be an advocate for 10 years in High Court. Can also be there. Very well there. Mode of removal of judge of High Court in India is same as that of removal of judge of Supreme Court. Absolutely correct. Any retirement from the office, a permanent judge of High Court cannot plead or act in any court or before any authority in India. After retirement from the office, a permanent judge of High Court cannot plead or act in any court or before any authority in India. Okay, so this is again, we saw it now only. One only, very good. Justice V.R. Krishnaiyer was once the Chief Justice of India. See how question 2008. Actually, he was not the Chief Justice of India. He was Justice of this one. P.N. Bhagavati became Chief Justice. Justice V.R. Krishnaiyer is considered as one of the progenitors of PAL. Yes, along with Bhagavati, he was also one of the important persons who originated it. Okay. So one is wrong. B, 2 only. Correct. With reference to Lokatalat can look into criminal case as well as civil cases. So even family case, but not with relate to divorce and all. So that is not there. An award made is non-appealable, no doubt about it. Okay. You see here, A, answer. If you see here, statutory recognition got in 1987, no appeal lies. It can deal with matrimonial dispute, land dispute, property dispute, compensation claim, compoundable criminal offense. Matrimonial means what? See, if the two parties come together, if the two parties say, sir, we are ready to finish it off or talk and accept it in Lok Adalat, they can go in before Lok Adalat and can take a call with regard to it. So look here. So these things we have seen few. Apart from it, Article 100, quorum relating to the Parliament, 1/10, 189, quorum in State Assembly, quorum in State Assembly, that is 1/10 or 10, whichever is more. Then 197, 3 plus 1. When Legislative Assembly passes a bill, it goes to council, 3 months they can put it wait, and another 1 month, either 3, that is 3 plus 1, 4 months max. They can delay, otherwise they can't do anything. They are not equal with Legislative Assembly. Then what else, like 202, 201 reservation. See, now the recent judgment relating to, see, all notes I will send, but just here. Recent judgment relating to governor and president is when bill is presented before the house, before, after giving passed, presented to the governor, first governor shall sign, no problem. If he doesn't sign, if he rejects it, then they can pass again as a fresh bill and go. If he uses suspensive veto and they resend it, he shall. President also same like president, governor also same like president, shall sign it. But in many cases recently, instead of signing, after resend, they reserved it. The court got agitated. And then normal bills also, they started reserving it. Now, normal bill can be reserved in the contention, in the mind of the judge, in the mind of the governor, that the bill may violate. In the mind of the governor, he thinks that the bill may violate, encroach upon High Court power, then he can go ahead with reserving. Okay. If he has reserved the bill, that means recent bill he has reserved, or any bill he has reserved, within 3 months, they shall say what they want to do. If they are not doing pocket veto at that moment, even president cannot use against state bill. This is what the judgment says now. Normally, they can resend it. If they send it back, they need not sign, president. As of now, as pocket bill, they are keeping it with them for more than 3 months. They are necessitated to sign it. This is what Supreme Court has stated. Similarly, ED and money laundering case, in my current affair and the question also I have sent it to you. There is one question where ED's power with relate to arrest in case of money laundering. Inquiry, he is also coming, means you cannot go for arrest. This is one item there. Minority education and institutions, if you see, this just So minority educational institutions, if you see, here the court overturned its judgment of Allahabad High Court judgment of 2006 and stated Aligarh Muslim University is a minority institution because they contested that it is actually today not governed by any person of that community. No, not like that. Even a government run or government, mostly government regulated institution is also a minority institution only. So the reason is that when the starting point has to be seen, when it was started. So that needs to be seen. This is what that case says. So unlawful activities, I have said to you. So many other current what I felt. One nation, one election, we saw questions. So are there in the notes, I would be sending it to you. All others, any doubt you are free to ask now. Any doubt you are free to ask now. If you have any doubt, feel free to ask now. Any doubt? Okay, I will be sending the notes to you all. Good. We were able to meet. Fine, Apurva. We were able to meet. And after the exams, we'll discuss the paper, hopefully. Be confident to go and write. Whatever I send with regard to polity, revise that. That would be enough. In my opinion, it's far more than enough. That itself will be too much more. But just revise them all. Just go through that once. So that will do the job. Fine. So thank you all. Thank you all. Okay. Thank you all. All the very best. Meet you soon. Thank you.